Commission, filling in for Mark Patterson today, who's out of state. I don't have much to say, except that for those of you who weren't aware, we had to cancel last meeting due to a power outage. So I apologize for that. It was the entire building. But we're excited to be back today, and particularly excited to hear from Fred and all of these amazing people who came in today to volunteer to help us understand the parole process a little bit better. So with that said, I'm just going to pass it right to Fred.
Okie dokie. So sorry about the backward here. So anyway, we had proposed to do 3 mock type minimums, and today we're going to do Class C, Class B, and a Class A type. A little bit of house cleaning. The bathroom keys are back there. There's the tray over there, but make sure you bring the key back afterward because they're kind of small. Clifford's snack shop is out there, so you need to take a break or have a beverage or sandwich or anything. Salad, I think he's got one left. Chips, it's all over there. So the handouts that you have here, we've had to redact them, alter them, prevent the innocent judges and stuff. Especially one sitting over there.
Not that innocent.
But we would like to collect all the documents afterwards. And just be advised, this is not, it's representative of the majority of topics that we use in minimum hearings. Now also be advised that we do use laptops that have flash drives that gives a whole history of the past inmate files and other documents. But the documents that we are using today is normally what the board has in front of them as hard references. So the way the board conducts minimums is there is one person who's the lead, and today I'll be the lead. And all the notes that I take go into the inmate's record. So no profanity, no derogatory stuff, relevant things to the decision making. All right. So other board members, they also keep their notes. And after a minimum hearing is complete, not after it's concluded, but after we've adjourned, the board will caucus, come to a decision, and we'll send out a written notice within 2 to 3 weeks to all relevant parties, including the inmate. Okay. So again, today's hearings are not representative of typical hearings, but meant to provide some of the hearing issues, dynamics of actual hearings that we do conduct. Because you can be a board member and for a year and not come across some of the things that you'll encounter later on. I mean, there's so many different nuances in hearings, as our retired board member can attest to. So these sessions are based on actual cases that have come before the board. Most of the identifiers, as I said earlier, have been redacted. Board members do receive a flash drive of all the files that we have, in addition to the hard documents that they reviewed 2 weeks prior to a hearing. Okay. So laptop computers are used, and in secure facilities, there are no cell phones that are allowed. So board members are allowed to use their laptops and flash drive for reference during the course of the hearing. And the lead, like I said earlier, submits all the relevant does all the note taking and turns it over to our recorder. Okay. So very quickly, as you can see, this board manual, this first one here, is an abbreviated version of what the board uses. We have updated the current board manual, which is about the 8th thick, that covers all the different type of hearings, acronyms, laws, case logs, and everything else. So the important documents that we use in the minimums are the fact sheet, which you'll see will be receiving a copy of these type of fact sheets that have all the charges. And back to that, we have the board action, which gives a history and chronology of previous board meetings, as well as the inmates' admission into the facilities. The court documents such as court order revocation, minimus, concurrent or consecutive type orders, mental health evaluations, if anything, pre-sentence investigation of the PSI, which we consider critical a critical piece in hearings, and sometimes, many times we don't get that. It provides a complete history as well as past programs, treatment, probation, social family background, criminal history, state and national. We'll also have letters from the Attorney General or the county prosecutor, as you'll see today. And what is very important is the initial prescriptive plan or the IPP. Okay. That plan is based on a one-on-one interview, as well as reviews all the relevant documents such as court orders, PSI, if it's available, and makes recommendations such as for substance abuse, mental health, sex offender treatment, any health issues such as medical, separatees, which we have gangs and we have people who will attack one another. So they need to be separated, as well as FRIA or previously abused individuals. Education, if GED is appropriate, and any other things. Also detainers and holds. We need to know if they have an immigration hold or another state has a warrant that they want to extradite federal sentence. We need to determine whether it's consecutive to the state sentence or concurrent with the state sentence. Criminal history rap sheet, which shows arrest and convictions, and it's for criminal justice agencies only. The supervision status, if they're on probation or previously on parole. And if they're a multi-state offender, meaning they have records in other states, and we access NCIC for that. Okay, any pending matters, police closing reports, especially for Class A and Class B, are very important. It also helps us determine state of mind or the seriousness of the offense. And anybody who is admitted or has been sentenced to a correctional facility for a felony matter, the board will see them within 6 months of their admission. Within that 6 months, they'll go through the RAD or the reception assessment and diagnostic process, and that RAD will come about with the IPP or the initial prescriptive plan. That plan, you'll see in some of these, will tell you what level of substance abuse treatment, or if there's any mental health or medical concerns that we need to be aware of. But it'll give the board a flavor as well as an understanding of the individual offender that's coming before the board. There are court mandatory minimums by law for repeat offenders. The board cannot go below that court minimum. It can go the same or above, but it can't go below the court minimum. On a side note here, some people think it's very, that the board is very callous and they don't, once they do the minimums and full consideration, that's it. However, in reduction of minimums or wrongs, the board meets once a month. And when an inmate is eligible, they can apply for a reduction of minimum based on the institutional behavior and accomplishments. The board will review that application and can decide, because it's based on the facilities and public safety's concurrence or not concurrence with that reduction in minimum. And the board can reduce that minimum, although we can't go below the court minimum. But we have been known to reduce certain minimums for lifers, Class A's and B's, as much as 10 years off their minimum, so that they'll be more readily available or eligible for parole consideration at an earlier date. Okay. So any questions thus far about where we're going with all of this? Yeah.
If you reduce a lifer's time, like how do you determine what that time is?
Well, if the board had previously set a minimum, and let's say it was 30 out of life on the life, and they come up within 15 to 20 years of their minimum, and they may have 10 years left on the minimum, the board, and if they're eligible and they submit the application, and the PSD or corrections and rehabilitation submits the relevant documents to the board, and we schedule it for an administrative hearing at the end of the month. The board will review each case and make a determination whether or not they want to reduce or not reduce. And if they do reduce, how much are they going to reduce it by? Then the board has a final decision on that. Notice is sent out to the relevant party and it's updated in the database, and it'll come out on these fact sheets of a reduction and when they'll be eligible for parole consideration.
So there's never a situation where life, like, I guess life without parole is what I'm asking you about. Like a lifer will always have some type of minimum.
Well, there's two types of lifers. Your life without parole, which they'll have to seek for clemency.
Okay,
Yeah.
I got you.
Versus life with possibility of parole, which is the ones that we see and set minimums
Okay.
on.
Got it. Thank you.
Okay.
And for the lifers without parole, there is a statute that says there needs to be in commutation review. That's certain.
Right.
So it's a different process. Okay.
Yeah, that's all totally different.
Yeah.
20 years. 20 years. Yeah, I think 20 years out, they review to see if they will come to life.
Got it. Okay.
But
And it's a pretty narrow group of cases.
Yeah.
Killing
Yeah, I know it's
multiple
small,
people,
yeah.
a police officer, prosecutor.
Judge.
Judge?
Yeah, I think being I was on the parole board up until 4 or 5 years ago. And we have to be nimble. Nimble is not a word we use in government, but we should be. We're the only state in the union that sets minimums out of 50 states. And we may disagree among each other whether we should. I think we should not set minimums. That's another question. But you got to be really nimble. And the reason is I think I trust the judges, but it's a whole other story. So, and in my mind, the parole board can and is and should be quasi-judicial. And I've seen boards that were not quasi-judicial. I gave a retrial to Marianne Bray. That we retried her from being a shooter to being an accomplice, and the board upped her minimum from something 30 or 40 to 110. That was wrong. So we finally got sorted that out. But so it's this question of being nimble. That's a kind euphemism for what I think we should do.
And as a follow-up to what Judge just referenced, that particular individual, a double murder, lifer, was on parole, did get parole, go through the Hawaii system, and while on parole did accomplish tremendous things as far as lobbying in the legislature, doing volunteer work, working with the YWCA. And after a while, after her review came up, we found it appropriate to discharge her. One of the few, but it does happen, but she was highly exceptional. Judge was sitting on the board at that time, and we did a thorough review of that. And you wouldn't ordinarily discharge a lifer, but I mean, she was so accomplished, and currently living in Las Vegas, living a good life. And but these type of things do come up in our administrative hearings each month. Okay.
Thank you.
Are there any other questions? So unfortunately, we did not circulate the documents online or scan it to our people who are not present. So you are the only individuals who are reviewing these redacted documents. The order that we're going to, normally, we will have anywhere from 10 to 15 to 20 cases scheduled per day, minimums. Minimums can take as short as several minutes, or they can take as long as 2 to 3 hours. All depends. Okay. What we'll run through today is Jessie is our number one recorder and boss of HPA. She'll be calling the cases, which you have an agenda for. We'll be doing 3 cases. One, a Class C, which is Doris Smith-Aki. And we have a Class B case, which is Terry Boy Miha. And we also have a Class A case, a lifer for murder. So if there's no other question, we'll go ahead and proceed. But if any questions regarding the handout, because as we go through these cases, you'll be reviewing the same docs that the board has. Of course, you know, like I said, we do use flash drives because the files can get rather thick. And, you know, we have, sometimes we review as much as 300 to 400 pages in the flash drive, and you can't be carrying that all around.
Does everybody know everybody here?
I believe so.
I see a Maui boy here.
That then,
We'll forgive him.
okay. By the way, does everybody have the first case, which is Doris Smith?
Hockey Smith. I think so.
No, you're pressed down off the middle one.
This one?
Yeah,
To.
everybody.
Oh, there.
Oh, yeah. So this first case will be by way of Teams or Zoom, and it'll be a double triple C. So the first sheet you see is the fact sheet. Behind of that is the board action, the previous board action. And you can see the initial prescriptive plan followed by a criminal rap sheet. Okay. In this particular case, we did not receive a pre-sentence investigation report, so you see how this plays out. Are we on with WCCC? Looks like it.
Stephanie, are you there? Yeah.
Hello. Yes, I am. Hi.
That is Doris.
Hi.
Yes, you want to call the case?
Today is Friday, March 15, 2024, via video conference with Women's Community Correctional Center. The Hawaii Paroling Authority is now in session. Present our board members, Mr. Young, Mr. Tan, and Mr. Dumaro. Case number 29, Doris Pocky Smith, in the matter fixing her minimum term of imprisonment. She is represented by Phyllis Hironaka.
All right, Ms. Bucky Smith, this is your setting a minimum hearing today.
Yes.
You were admitted back in August of 23 under criminal number for probation revocation, and this is an open 5 case. We do note on record that you have a probation revocation as well as 1,186 days of credit. So we're going to open with your attorney making representations, followed by you, and the board will have questions after that. All right?
Okay.
Counsel?
Yes, Deputy Public Defender Phyllis Hironaka, appearing on behalf of Ms. Pocky Smith. Before we begin, I want to note that there appear to be 2 assault second convictions in the records. And so I am asking first for clarification, and then if it plays out the way I assume it is, then I would be asking for a continuance. And let's time out right here, which is that because this is a demonstration, and we'll just proceed with the particular case that we have. But it looks like Ms. Pocky Smith was convicted of assault second for allegedly an assault on her boyfriend here in Honolulu, First Circuit. She also has an assault in the second degree conviction for an incident on Maui, Second Circuit. And the only case at issue this morning is the Oahu case. And so as her defense attorney, it would make no sense to proceed with the minimum hearing on the Oahu case without knowing what the status of the Maui case is. If she is still on probation, as I suspect, on her Maui case, and the Maui attorney needs to investigate and consult with Ms. Pocky Smith as to whether it would be more favorable to her to have that Maui probation revoked, because right now she's not getting any credit for time served on the Maui case, and yet she's getting credit for every day that she's serving on the Oahu case.
Sure.
Then also for the board's setting of a minimum, if you're setting a minimum on 2 assault seconds, of course, the minimum may be higher than if you're only setting it on 1 assault second. So these are critical factors that need to be taken into consideration, figured out before we proceed on the assault second or the Oahu case.
Okay, does your client know what happened or how that Maui assault second was disposed of?
Yes.
Yes. Go ahead, Doris.
Okay.
Tell the board what you understand as far as what's going on with your Maui case right now.
Okay. So, I know that I got arrested for the assault charge here, and that one was on my boyfriend. And then I got supervised release to Maui to my father. And my father, who's kind of abusive, he we got into a fight one day, and he backed me up into the corner, and I threw a picture frame at him, and it cut his leg. And so they charged me there, even though I was on probation for the first one. They charged me with another assault charge. And because my sister was in the room, I also got charged with abuse of a household member. But that one ended up getting dismissed. And then I got charged with the assault too for my father. And then all I know is they brought me back from Maui back to Oahu.
Okay. Counsel, do you still want to move on that or not?
Well, she can't tell me if she's still on probation on the Maui case. It is a conviction.
Mhm.
And so at this point in time, I would recommend that we continue the hearing, the minimum hearing, until we find out the status of it.
Well, we have the Maui prosecutor here.
Okay, so that in reality, that's where we would probably leave it this morning. But because we had intended to do the demo of the Class C, we'll just proceed
Yep.
as if that issue is resolved.
So what I think happened was I was on probation for 5 years with the boyfriend, stabbing my ex-boyfriend. And then, if I'm not mistaken, they put me on probation for 2 years for my dad's assault charge.
Your probation out? on
So
that amount?
I'm not sure if I'm on probation still for the Maui one or if that's finished already.
Okay, so let's take a break, and we're gonna just proceed on the minimum for the Oahu assault case, okay?
Okay, board members, question.
Wait, I haven't made a presentation.
I thought you were doing it all.
No,
Go ahead.
Kelsey, my question is if it's all right with your client. You're the agent, she's the client.
Correct.
Does she want to go ahead?
well,
Yes.
the break is basically because that would be an issue.
I
that we
understand.
would probably not have the rest of this
All right,
hearing.
let's make it as real. You want to go ahead?
Yes.
Okay, counsel for
Okay.
argument.
Okay, for arguments, Ms. Bucky Smith has had a very troubled life, in the sense that she grew up in a very dysfunctional household, full of domestic violence. That's all she saw since she was little. Dad abused mom regularly in front of the kids, and dad abused the kids as well as quote unquote discipline. So that's all that Doris really ever knew. And so, of course, when you're raised in that kind of an environment, that's how you react to trouble or disagreements in your own life when you're an adult. She had different boyfriends, had children by different men. Each of them was abusive to her. But Doris tried really hard to make her life and that of her kids better. She got into programs, she accessed services that were offered to her. And there were times when she did really, really well. And then there were times when she didn't do so well. Part of that is along the course of her life, she has been diagnosed with schizophrenia, but there were times when she did not recognize it, wasn't taking her medication. And that clouds your thinking, of course. And there were times when she did, take her medication and understood, how the mental health aspect was primary in her life. I believe, but Doris, you're going to have to explain to the board, at the time that the incident with the boyfriend happened, you were not on your medication. Is that correct?
Correct. I was on drugs.
She had this, okay, from the fact, first of all, there is no PSI. So what I understand from my client as to what happened is that she had a boyfriend here on Oahu. He was staying at a hostel in the Waikiki area. Doris lived there too. And then at some point in time, Doris got kicked out of the hostel, but she would go to visit the boyfriend at the hostel. And they got into an argument. And then she ended up stabbing the boyfriend in the back. She doesn't remember much of the details about what happened, what the argument was about, where it occurred, the knife, any of that stuff. So a lot of the details came from the police report, but that's really all we know as far as what was going on. You folks, of course, can ask Doris about what she was thinking at the time or if she remembers. That's essentially the nuts and bolts of the case. Now, I know that you folks look at there's the grid for determining the level of punishment. And so there's level 1, 2, and 3. And because this is a C felony, the max that she can get is 5 years, which is the top line there. Level 1 would be 1 to 2. Level 2 would be 2 to 3. Level 3 is 3 to 5. So I'd like to review the factors that the board should consider in determining whether she is a level 1, 2, or 3 offender to set the minimum. The first, of course, is the nature of the offense. And in my argument would be that she could be a level 1, 2, or 3 because as to any of them. Level 1 is that the offender displayed a disregard for the safety and welfare of others, which she did. Level 2 is that she displayed a substantial disregard, although not multiple counts, for the safety and welfare of others. So in that aspect, she's technically not a level 2. Level 3 was a callous or cruel disregard for the safety and welfare of others. I don't think that a single stab in the back, again, that's my opinion, counts as a callous and cruel disregard for the safety and welfare of others, but that's for the board to determine. The offense is not level 3 because by the involvement of manufacture of dangerous drugs, it wasn't against an elderly, a handicapped person, etc. So in that regard, she is not level 3 by nature of offense. With respect to degree of loss to person or property, level 1 would be less than those experienced by similarly situated victims. Comparable to those is level 2, and more than those would be level 3. My contention is that Doris is a level 2 as to that degree of loss to injury or person stabbed in the back, and it wasn't any more significant or involved in that. Criminal history, Doris has no criminal history or very little criminal history. Level 1 would be if the person has no more than one prior felony conviction. This is her first felony conviction, although we have the Maui case, that's a question mark there. Level 2 would be if she had 2 or more prior felonies committed at different times. And again, so she could be a level 1 or a level 2. Going to character and attitude, criminal life, regarding criminal lifestyle. Level 1 would be unlikely to recidivate. Level 2, possible recidivation. Level 3 would be probable. And I would say that Doris is probably a level 2 because although she has made great strides in trying to improve her life and to follow the rules and work with the system, etc. The mental health aspect is something that is of concern that, it may cause her to recidivate if she's not on her medications. On the other hand, if she's on her medications, she could do well with flying colors. And I think the judges saw that because they gave her probation, both for the Oahu case and for the Maui case. The other criteria about efforts to live pro-social before prison. Level 1 would be if it is likely that she will respond positively to a program of parole supervision. And I believe that Doris falls squarely within level 1. Partly because the judges so saw when they granted her probation and they were acknowledging her excellent, efforts at self-rehabilitation. Level 2 would be it is possible with proper support that she could live pro-social. But I lean more to level 1 in this particular case based on her track record. And level 3 would be it is unlikely that she would respond, which I don't believe fits in this particular situation. With respect to probation revo, she would be a level 1, I believe. Technical violation probation or new conviction for a misdemeanor offense. Young adult does not apply to her. Involvement of the offender in the incident offense, that criteria, it says level 2 or 3, either she had a substantial role or she was the instigator or leader. And since she was the only person who was charged with stabbing the boyfriend, then that would be level 2 or 3. There are additional criteria that the board considers, only one of which affects or impacts Doris. Involvement of the offender in the instant offense was that she reduced the injury or loss to the victim. That didn't happen. That she played a minor role. That's not applicable. That she cooperated with the state, like the police or the prosecutor, not applicable here. Diminished responsibility. That at the time of the offense, she was suffering from mental illness or severe emotional stress. Clearly, there was an argument with a boyfriend. It's an emotional thing because it's a domestic relationship, and she suffered from mental illness that was not being treated at that time. So I would say that is a factor that would mitigate her level of responsibility. And the last criteria for consideration about degree of provocation or involvement by the victim, the boyfriend, I don't know. So Doris is going to have to explain if she can remember whether the boyfriend provoked her or how this fight came about where she ended up, stabbing him. And it may be that the boyfriend, was quite a contributor to the argument and the results. So based upon that, I am requesting that Doris Bakke-Smith be given a level 1 level of punishment, or at most a level 2. Thank you.
Thank you, Counsel. All right, Doris. What can you tell the board about your involvement with the offense you were sentenced and convicted for?
So I had a boyfriend, and we were living together in the hostel, and then he kicked me out. We broke up and he kicked me out. And so I was living on the streets in Waikiki. And one day I was walking down that road by Queen Kapiolani, and I saw my boyfriend or ex-boyfriend, and then I chased after him, and I ran after him and ran to his house and followed him up into the house, and we started arguing, and then I just stabbed him. I grabbed a knife and I stabbed him in the back. And then I ran away because we were arguing.
What was the argument about, if you can remember?
I don't remember, because I just know that I was mad because he broke up with me.
Okay. And when you saw him on the street, did he say anything to you that?
I actually ran away. He tried to run away from me.
Okay.
All right, so Doris, were you on drugs at that time, under the influence of drugs?
Yes. Yes.
How long had you been using drugs?
I had been using drugs from around for a couple years now, and I had become homeless. So I was living on the beach in Waikiki, and I was smoking meth. I started smoking meth so that I could stay up all night, because it's scary on Waikiki and you can get raped. So I would smoke meth to stay up all night, and then I would sleep on the beach in the day.
Okay, and how much were you using?
Probably like a gram a day
I'm a day, it's kind of a lot, yeah?
or whatever I could get my whole hands on. Yeah.
How were you supporting your drug habit?
Well, I had money because so my father, was disabled veteran. So I was getting $500 a month from my father's disability for me. And then I had my own disability, which I had Social Security disability of $900 a month.
What about your medication? Were you taking your meds?
I wasn't taking my meds.
Why?
How come you weren't taking your meds?
Because I was too busy getting high.
Self-medicating?
Yes.
Okay, well, let's see what the other board members may want to ask you. Yeah.
Go ahead, Gene.
Okay, good morning, Doris.
Good morning.
So you said that you saw your ex-boyfriend on the street and you chased him into his house,
Yeah. Into the hostel.
to the hospital.
Yeah.
And where did you grab the knife from?
Well, I chased him up to his room, in his house, in his kitchen.
What kind of knife are we talking about?
Just a kitchen knife.
Big blade, small blade?
Not real big, but just whatever was right there. Kind of like a steak knife.
Big knife. You stabbed him in the back.
Yeah.
Was he trying to get away from you at the time you stabbed him?
Yeah. He didn't want to argue with me. He didn't want to talk to me.
What kind of injuries did he get from the incident?
So later on, I learned that because I ran away. So later on, I learned that he had the police said that he had like a 2-inch cut on his back.
How serious were the injuries? Do you know?
No, I know that the people downstairs called the ambulance and he got treated by EMS. I'm not sure if he went to the hospital because I left already, but I know that he was bleeding.
Okay. Did you make any attempt to help him at that point? Render
No.
aid? Call anyone?
No, I left.
Okay. So your counsel earlier touched upon one of the factors being character for the board to consider in setting a proper minimum term. I noticed in the report that you incurred several misconducts while in custody. Is that correct?
Yes.
And you also had multiple opportunities on probation which did not work for you?
Yes.
How come probation didn't work?
Because I was homeless by then, and every time I got out of jail, I went back to the same thing, just smoke dope and live on the beach.
But you weren't interested in what probation had to offer? Safe to say?
Yeah.
Not ready to change then, huh?
No.
Okay, that's all I have. Thank you.
Morning.
Morning.
I'm retired Judge Mike Town, and I
Hi.
wanted to, should I call you Miss Pucky Smith or Doris? How do you like to be?
Doris is good.
Sure. Okay. Just don't call me late for dinner. All right.
Okay.
Doris, how old are you?
31.
Okay. I had down here a
I
little
think
old.
it's 44.
Oh,
yeah.
maybe 44? Okay, wait. I think that's a lot.
I don't know if it's right or wrong. We make mistakes in government. It says you're 44. Is that okay?
Maybe I am 44.
Well, it's important to me because it shows, hopefully life gives us a little maturity. How many kids you have?
3.
Who's taking care of them today?
My brother
And you have any
and my mom.
children?
No,
Do you have any grandchildren?
not yet.
Not yet. Well, I hope you get some and you're happy. Okay, I'm just checking this out. When you get out, what do you want to do with your life?
Well, I know that I don't want to do drugs anymore. And I know that um, all of this stemmed from me being high and not being on my meds. And today I know how important my meds are for me. So being here in WCCC, I'm taking my meds. I don't hear any voices anymore, and I'm trying to do good. But, a lot of the girls here, they don't like me. So I get into fights.
Have you ever been in placement for drug and alcohol treatment like Sand Island or like Habilitat?
I believe I tried to go to treatment, but I always just ran away.
All right, that's all I have. Thank you, Mr. Chair.
Okay, Doris, my last question to you is, how long have you been clean and sober?
Only since I came to jail.
Which is,
So, when I went to jail the last time, because every single time I got out, I used again. So the last time, I think maybe from 2022, because I went to OCCC the last time in 2022, and I've been in jail and then prison since then. So that's when I got clean, I guess, in October of 2022.
thank you. Board members, any other questions?
Thank you.
Council, so you want to proceed on this matter and then we'll research the other matter, and if we need to set a minimum, we'll come back?
Yeah, that sounds like what's happening.
Okay. So Doris, the board will deliberate on your case. You'll be notified within 2 to 3 weeks in writing what the decision of the board is, all right?
Okay.
All right, good luck to you.
Okay. Thank you.
So in this particular case,
We're off record.
we're off record. So in this particular case, I was sitting on that case. I don't know if Gene was, but with the amount of credit for time served and with the presentation by the then Deputy Public Defender, he made a very compelling case as far as her efforts to rehabilitate, success on probation and failures and slippage and everything else.
That didn't come out of this hearing.
No.
At all. Yeah.
No. But this was based on the case that I'm putting forth to you and the decision of the board at the time. So ultimately, with her probation history and her back and forth and her desire to go back to Maui and her sobriety and programming, the board ultimately gave her a level 2 at the lower end, which was 2.1 years, which pretty much put her over the credit for time served. So it could bring us back for earlier parole consideration hearing, review her parole plan, and if acceptable, parole her back to Maui. So, I mean, these are some of the nuances people will not see on any kind of normal hearing, but this is typical of how these hearings are conducted and the extent that the board has to ask questions. And a lot of it, in this particular case, the self-reporting, we didn't have the luxury of the PSI or the police report, which would have told us more about her social history, substance abuse, and psychological psychiatric issues. But again, with all the information that we did have, we were able to render, I think, a fair decision as far as getting her back on parole, back on her feet, but recognizing the good behavior that she did while she was on probation. And ultimately, the court, with the last violation, had to give her the open term. But it's not that the the courts didn't do their best efforts, but the board recognized all of that.
Why didn't you have the PSI and that underlying?
There's many times that a judge may not order a PSI, and we have that a lot.
It's mostly neighbor islands, right?
Yeah.
A lot of it is other islands. Sometimes we have it in the First Circuit, but it's what we have to work with.
I know when I first got on the bench, I didn't know how important it was and that the paroling authority needed it. I learned that. But I don't know if the judges are getting trained in that to point that out because it really is important.
So, and also the victim wasn't present. Sometimes our victims present at these.
Yes. A lot of times a victim witness advocate through the prosecutor's office may say that they want to make a presentation statement and they're allowed to come in.
Okay, so if they don't have the PSI, which would have perhaps a victim impact, and if they don't have that, the victim present, then I'm looking for a third place that maybe victim would have to put is the efforts made to live post-social prior to commitment. So in that period of time, maybe from the incident until post-conviction commitment, how do you know what's going on specifically to the victim, but in general, how does that information?
Many times on a victim witness office, they'll initiate the request to appear.
And Fred, do you also get comments from the prosecutor's offices?
Oh, yeah.
Yeah.
You'll see that in another one.
If I can add to what you were saying there, the efforts to live pro-social, they're looking at the defendant's efforts to live pro-social, right? So the victim, a lot of times the victims don't respond in time to the PSI writer's request for information, or they choose not to make a statement. So the PSI writer has nothing to put in their PSI.
Right.
So it's a zero. Or they'll also ask the victim, do you want to claim restitution for medical injury, whatever it is. If they don't respond, they have nothing. And so there's no input from the victim. And this is sort of my personal opinion, but a lot of times, like say in this situation where you've got a homeless woman with mental health issues and drug issues, and the boyfriend a lot of times has similar kinds of issues. And so they're not responsible enough to be able to, fill out one of those forms and send it in in an office kind of way. So it's that's why there's no information.
As a victim, I work with victim witness services. But a while ago. But often we would have people calling because there were threats or kind of ongoing behavior. And that's what I was kind of looking at, how that information would get in or how you would become aware of it.
Threats by who? Threats by the
defendant. Oh, because that's going out for social behaviors. So I'm just trying to thinking, how is that getting in now if the person isn't, in this case, that I understand exactly what you're saying. So that was really helpful. But I'm thinking then applying this.
Sure. So the PSI report, that's something the judge orders for sentencing, right? And I know a lot of know the answer to this, but some don't. And so when they're waived, it's usually by agreement of the parties, right? And that typically happens on neighbor island. So the HPA doesn't have the authority to order a PSI, right? Only judges can.
Yeah.
And so if there was an issue that came up and say a judge was setting the minimum, they could do something like that, right?
Well, what I've seen with judges is some of them in the past, and I had a meeting with Mitch Roth earlier, years ago, is that some judges will say, I know what I want to do, so no need a PSI. You guys are short staffed, counsel you stiff, and if defense and prosecutor stiff, they'll go. And that's allowed by the statute. And go ahead.
Ben, what I heard was forgive me, the Big Island judges didn't want to do it because probation was grumbling. They had too many cases. They were short-staffed, and they were. And the judge knew what they was going to do. And we strongly argued to them, don't do that. We need it. We meaning the judiciary, the record, the parole board. As a parole board, we couldn't do anything about it. I think it's up to the judge. I don't know if I've been a judge for 12 years, so be it.
And if we can't get a PSI, we'll ask if they're on probation, we'll ask for the probation officer's report. And then we get something. Well, it's confidential. It's not confidential. We can request for it.
Steve, you agree there should be a PSI?
Absolutely.
Because it may drive the sentence down or the minimum down. What bothers me is that we're the only state in the union that sets these minimums, and that Fred and I have an honest disagreement on that.
Right. And so, just so that we're all on the same page, PSI is also the opportunity not only for the defendant to make their presentation, but that's where you reach out to the victims and the victims'
Yeah.
rights advocates too. Right.
Right.
I want to hear what Daphne, you there? You went away?
Yes, I'm here.
How did you feel as you're baking in the fire, young lady?
Well, I was actually there for that case.
How did you feel? Did you feel fairness? Were we too gnarly or not gnarly enough? What do
No,
you think?
I think it was good, and I feel she got appropriate. She's not really, because that client was not really a bad girl. She just had a bad upbringing with a lot of domestic violence, and she doesn't even know how to control herself. You know, she doesn't know why she did that. She had stated that to me, that she doesn't know why she got so angry and, you know, threw the picture frame at her dad or stabbed her boyfriend. It just,
You can understand a stab in the back could easily, in my mind, maybe I'm wrong, Steve would know better, is attempt murder or assault with a
Yes.
deadly weapon. Not talking 5 years.
yes. But at the time when you're in the moment, I don't think you realize that.
She didn't know jack about her kids. Most of my inmates know their kids, you know.
Another thought.
Yeah.
So what does the board do when the defense counsel makes a presentation saying, you know, at the sentencing judge made a comment saying that this minimum should be a level whatever? How much deference does the board give?
Well, judges, I've not seen any judges make that kind of recommendation, and for whatever reason, you know.
I think the
don't
only
know
time
there
that
are-
would happen is if there's a mandatory minimum,
Yeah.
that we reduce it based on strong mitigating circumstances. Can I just interject?
Go ahead.
that-
Yes.
And I'll be the first to admit it, the First Circuit was split. But, you know, in most cases, most felony cases, there will be a pre-sentence report.
Right.
The only time we don't order pre-sentence reports is if there's a plea agreement where the defendant is pleading to a misdemeanor and under 706, 604, it's not required. Or if there is a Rule 11 of plea agreement where in the agreement itself, the prosecutors and the defense attorney designate that we are not going to order a PSI. We have a full agreement hammered out here, and we're not going to wait for the PSI. But those are the only limited situations in the First Circuit where we don't have a PSI. Otherwise, every other case of a PSI. And let me just say, with respect to the PSI, I would say, and I think I've said this before in the context of this committee, 80+% of the PSIs that I read, and I read them on a daily basis, when given an opportunity for the victim to weigh in, they decline. They never get back. And we got a really good group of probation officers here in the First Circuit who write the PSIs. They're very good at what they do. They're very thorough. But 80% of the time or north of that, we don't get any information from the victim. I will say that in those 10 to 15% of the time where we do have a victim impact statement that is appended to the PSI, that's very helpful to me. As I said,
Good, Judge. Yeah, and I agree.
Behind you.
Oh, I was just gonna add to Kevin, Judge's, statement about, the other instance where PSIs don't seem to be, ordered is if there was one that was recently written and they rely on that one. Like there may be two cases that came down close together.
Again, under 706, 604, there is an exception. If there was another PSI done within 1 year of the sentencing, then we don't have to order a new one. But even in those instances, I'll order an updated PSI so that it will reflect, and it's a shorter process, but it will reflect the new offense, give the new victim an opportunity to weigh in. And the reason why that's important too is not just for the victim to weigh in, but for when you have a new case, there are new issues of restitution.
Right.
So if you don't order an updated PSI, you oftentimes don't get an updated PSI for the new case.
Yes. Thank you, Fred. First, quick question, or I'm sorry, first comment first and then question. The comment is the PSI process is critical for the victim because that's the process by which their input is elicited And when it doesn't happen, or it doesn't happen properly, then that input isn't going to be part of the process. And often I've seen that the difficulty arising when they're someone wants to go ahead and plead and get sentenced right away, everyone agrees on it. But that means the victim doesn't know even that the hearing is going on, and then that doesn't have any opportunity. The other part of that is a lot of the victims have told us that appearing at parole minimum hearings is much more supportive than appearing in court. And part of the concern is that if they're in open court, then his family and supporters are all there. My question has to be, when you're doing the minimum, do you inquire with the offender about their attitude towards restitution? Because just in my opinion, that's what sort of the base elements in determining whether someone is willing to take responsibility. If their attitude towards restitution is poor, then I would question whether or not the person really wants to take responsibility.
Well, for the minimum hearing, we normally don't ask about their attitude towards restitution because we'll have it either in a board action or the court order as far as what the restitution amount is. Okay. Sometimes we may remind them that they have a large amount of restitution, but as a general rule of practice, we don't ask about attitude towards restitution.
Just a couple of comments. Because of the way you have it set up with guidelines, it gives the public defender something to be trying to objectively fit the facts into. And it is, I've thought of what Dennis said, it is a more relaxed kind of a setting, I think, than in court. And you essentially have three judges, three perspectives giving their take on it. But one of the biggest differences is the back and forth you guys have with the defendant, which is, in my experience, did not happen in court because often on counsel advice, they're not going to say anything. And yet you really have this back and forth discussion and you have the number of months they've been in custody and what their behavior has been. And I trust the judges to take all these cases seriously, but my concern is the inconsistency that would result. We're all different people. Everybody in this room, if we were all judges, we would have different sentences every single time, would be my guess. And the paroling authority being statewide provides consistency that would really be missing in court, no matter how seriously, Kevin takes each case, he is different. It's like, probation officers. Gene?
So one comment on victim input, we do receive a lot of letters from victims, and that is read and considered by board members as well. Sometimes we read from the letters in the hearings when confidentiality is not an issue. But in my experience, we receive more letters than we receive in person attendance at the hearings.
Jane, as we know, in Europe, the victim is a party. They don't have to rely on the prosecutor. Just think about that for a minute. That happens in almost all of Europe. But we have, I'm not real happy with some of the Europe things, but this is a good one. Andrew, you had a question?
Well, yeah, I actually wanted to come back to Ben's comment because about the judges making recommendations for setting a minimum at the time of sentencing and outside the realm of the mandatory minimums. And I think Ben is making that comment because you probably both seen it happen in the Second Circuit on more than one occasion. And since I know it wasn't in any of the cases that I had with Ben, I know particularly in some of the more egregious cases in the Second Circuit, judges will make recommendations. I mean, two that come to mind is I think Judge Cardoza did so in the Capobianco case, and I think Judge Cahill did in the Stephen Schmidt Foodland murder case. And so, on my end, when I get those recommendations, I print out the transcript, I attach them to my comments to the board. So I am curious about if those cases or other cases do jog your memories about your consideration of the judge's comments and how much weight you give to that, just because part of the discussion is, to Judge Towns' point, what you do lose in this process, there are a lot of advantages to it, but what you do lose is that intimate knowledge of the case throughout the entire pendency of all the litigation. Right?
When I started, I have to separate being a retired judge, not a tired judge, retired judge, and doing this. We told people, I would tell judges, stay in your lane. stay in your lane. The one case I remember, somebody in a horrible death dismemberment case, the judge said, you know, if I had the authority, I'd put you to death. Phyllis probably remembers that case, and he's a really good friend, and that did not work. That backfired throughout the entire case. So that's my advice, at least stay in your lane. We just talked to 15 new judges the other day with CJ and Mark Browning and I. 9 were women, and they were an amazing crew. I have great hopes for the whole deal. So that if maybe you disagree with me, Andrew, stay in your lane.
But to the extent that it can provide an additional perspective, and
Yeah.
maybe Ben's seen it go the other way. I've seen it usually way in favor of a more serious minimum, but maybe you've seen it go the other way.
Yeah.
But to the extent that it provides that additional perspective, that's different from one that the board is gonna
So
get.
let's say the couple Bianco, and we've heard all kinds of stuff reported by the media, what attorneys say and everything else. The board is a quasi judicial body, and it makes up its own independent mind. And we try and flush out all the side, pardon the expression, crap that is out there. And I think that's the beauty about 3 people. We may not agree all the time, and it's a 2-to-1 vote that would rule, but we have to stand as one. But any of the side garbage that comes out, we have to put it on the side and just take it for what's recorded and what we have to make the decision.
See, and so as far as,
Go ahead.
can I, and not to cross-examine, sorry, but but I mean, the question is, what does that carry weight in terms of consideration, and does it merit weight given just the understanding of the breadth of knowledge that the judge has, and not reviewing documents and having a moment with the offender, but a series of moments and listening to evidence over the course, because I think this can weigh both ways,
Yeah.
right?
But judges are individuals. They got their own opinions. Some of them have their own agendas, and that's fine. But as a board, we have to take what evidence is presented here. And if it's if it's a police closing report, the forensic reports, the mental health evaluation, or a 404 evaluation, we'll have to take all of that into consideration before the board, because our decisions are challengeable. But we've been challenged on it many times, and Supreme Court has ruled against the board's decision. We've had to hold rehearings on the matter. But one last thing on the PSIs, which I think has been missed, is that the PSI is a critical element when the individual comes into prison. When they do their intake and assessment and diagnostic, without that information, it's all self-reporting. And sometimes when it comes to the board, we'll see no drug treatment. Well, we know this person is a chronic, and so we'll send it back for reassessment. But that PSI is that critical piece on admission into corrections, and not just for the board. Because out of that RAD comes the IPP, or the prescriptive plan, which the PSI and other reports help put together a level of drug treatment or mental health watches or medical issues. And I can't emphasize enough how critical a piece it is for corrections. And then with the RAD assessment and the IPP, or the initial prescriptive plan, that's one of the key documents that we look at in setting a minimum. And, with the various levels of punishment and criteria that we look at, again, it's a critical piece in making that decision. And again, we may not all agree, but we're pretty close as far as how we would come to a decision with the board. Now, be advised that the minimum is the minimum time that they would spend before being eligible for parole. Doesn't mean they get parole, but it just sets a time frame for them to shoot toward. And if they have to complete programming, such as sex offender treatment, that's a 2-year program. If they're at a level 3 in RDAP, substance abuse, that's about 18 months. So we don't set the minimum based on programming, but we would set the minimum based on levels of punishment and what's reported in the hearing itself. Yeah.
And that's, and I hear what Andy's saying, but 90% of the cases that come before the judges are plea agreements. So we don't get intimate, they're guilty, we don't learn the facts that much, or if we it's the facts of the case. We don't learn that much about the defendant. No, some of the cases that go to trial and the pretrial motions and stuff, we may know more, but we know more usually about the case, the facts of the case, not about the defendant. So, most of the time, the PSI is what we have and hearing from the attorneys. And the last thing, even if there's no PSI, I believe the judge can order the POs to do a restitution study and to try to get that information out there, because that's really needed.
One brief comment about the Oversight Commission. It's not the Nearsight Commission anymore. We've got Kristen here. We got good people. We hope we're going to get funded up. Judge Browning, myself, and Judge Ibarra on the Oversight Commission. The new deal, and it is unfortunately news, is rehabilitation and correction, not punishment. So when the thing all shifts to punishment, I get excited. That's the wrong perspective. And Kristen, do you have any comments on any of that? You don't have to say anything. Maybe too much of a softball question.
I have no comment.
Okay. We're trying real hard to rehabilitate.
Last one, and then we'll move on.
Yeah, sorry. I'm sorry, just a couple follow-up questions. When you guys are setting the minimum and you guys are looking at the RAD assessment and IPP, determining what the program is individual needs to do before they should be eligible. Do you guys have any inkling at that point of what particular facility that they're going to go to? Because sometimes inmates can get programming done quicker, let's say in Arizona, versus if they stay here, or if a sex offender has to go to Tulani. Do you guys take that into account at all when looking at the RAD and the IPP, or is that something you guys, it's not your fully honest?
It really falls with the department and their placement and based on custody level. So different facilities, for example, if they're in medium custody and they got to do sex offender treatment, they have a medium custody at Halava, they have minimum custody at Kulani. So depending on their classification, where they go. If it's drug treatment, it's what they call RDAP 2.0, 2.5, and 2.0. So depending, again, minimum at Arizona, they'll do a 2.0 or a 3. If they're for 2.5, they may as well take the 3.0. But again, it's their placement in facility is not program contingent so much as custody level. And then when they advance in their custody level and they get go from close to medium to minimum, programming is more available. And as long as we got people to start the program, they're there.
Second question, I tend to ask a lot of questions and try to solicit a lot of comments and from the particular defendants, mainly about, what they learned from this experience, what assurances do I have that something like this is not going to happen again, so on and so forth. I was though very surprised with this particular example as to how forthcoming the inmate was about what she did and why she did it. Now, if let's say, for example, you have a case where you don't have a PSI, let's say it went to trial and there's a pending appeal, and based on the advice of counsel, you have an inmate saying, on the advice of counsel, I don't want to talk about this. Part of your consideration here, many factors you guys are looking at are offense variables. And so how do you handle that in that situation?
You'll see in about 1 hour.
Okay, thank you. Very good. Thank you.
Judge had to make a quick exit. He'll be right back. But any other questions regarding this particular case or the minimums at large? Yeah, sure.
So about the waived PSIs, when I worked at probation, if there was a waived PSI, then we would do a post-sentence report. So that would take the place of the PSI, because you can imagine how difficult it is to supervise someone on felony probation without knowing anything, right? So I'm setting the minimum, but it's even worse trying to supervise somebody without any information. So post-sentence report was done. I don't know if the practice continues to this day, but if it does, at least in First Circuit, if you're able to get a hold of that, I mean, that would be really helpful instead of looking at that.
I've never seen
I've never seen it, but like I said, in the First Circuit,
Well,
we always have-
because post-sentence reports would now come under the umbrella of probation records, right? PSIs by law, it's, you distribute it to certain parties, right? But not post-sentence. Post-sentence reports are not governed by any.
within
It
probation.
stays within probation, so now it's governed by probation records. So I mean, if there is a statutory fix.
What legal authority would there be to generate post-sentence?
So it's an internal practice, so that's why I don't know if other circuits are doing it, but at least for First Circuit, while I was there, that's what the practice was.
Does council have an if it goes into
It never-
how the
it never
defendant
went to
supervised?
council. But it was simply for supervision.
Okay, so it's sort of like a supervision tool in terms of a risk needs assessment, things like that.
Yeah, it's actually like a PSI, but it's called, we delete that and call it post-sentence report instead of present report.
So a judge could order it at a revel hearing for resentencing purposes?
I've never heard of it ordered.
We have a violation report.
Yeah.
We usually get that.
Yeah.
That's right. It sounds like something that they generate at sentencing prior to a violation.
So Cheryl, is that done on the front end within
It is
probation?
done at the front end, right after sentencing, because now the PO knows that there's no PSI.
So where does the info come from that makes up the report?
So that the PO then would schedule an appointment with whatever the or the defendant.
So a lot of self.
And then run it like the PSI.
I see.
And so the only time that would come into play in this context though is if the person ultimately gets revoked from probation and then they would get their hand on it, right? Because if someone's placed on probation, they would
Right.
So for those of you who are not familiar with Cheryl, she sat on our board till Steve stole her away. And she was a big contributor to helping us develop the cheat sheet for setting up the minimums matrix. So, Cheryl comes with probation experience, sex offenders, and board experience. Until Steve stole her away. Chris,
I have a question. So, not to fixate on the PSI, but if the neighbor islands are less likely to have them done because of some staffing issues, like, could that also mean that neighbor islands are more likely to get more severe sentences because there's?
well, Hawaii's indeterminate sentences, so it's basically 5, 10, 20 life extended. And some of the judges, of course, have been exercising a certain discretion with some of the lesser cases to give them shorter sentences under those less than open 5. So it's nothing that, I mean, by law, they're locked into indeterminate sentencing structure, So
that's only drug cases. Only PDD 3 under 706-660 subsection 2. The judges can give a no less than 1 year, but no more than 5. So the only time that's going to show up is the PDD, the promoting dangerous drug, 33. It's the basically the possession of pipes with residue, small amounts of drugs and things. So, but that's the only time when we have the legal authority judges to make some violence.
And I think the feeling, and it could just be my perception, was that neighbor island judges may have been more likely to give the open term than probation, partly because there were no treatment programs in the neighbor island. They used to send more kids to HYPF than the percentage of the population. And I don't know if that's true now because the judges have changed. But I don't know if any data has been done on that. Open term versus probation, in or out. Fred said it's going to be 5, 10, or 20. It's 5. The in or out decision, I don't know if there's been any research about that.
It would just be interesting to see how the searches differ,
Yeah, it would be.
especially if you're saying the PSI is imperative, and
Yeah.
the neighbor islands don't count them as much.
Well, just a real quick one before we move on. We're having a lot of problems with Third Circuit years ago, I met with Mitch when he was a prosecutor. And I attended the quarterly judges meeting and we resolved a lot of that. And then it cropped up again. We had a meeting with Sheldon and Palmer, Robert. And at least the understanding we came about with is that if a PSI was generated within 2 to 3 years, just give us an update. Something for that our RAD people could review and do a proper IPP, initial prescriptive plan and RAD assessment. So it's not that anybody's just not extending themselves, but when we see a problem, we'll go and try and nip it in the bud or make some type of adjustment. So anyway, we're going to go on to the Class B, and Judge Town is going to take the lead on this. So Jesse?
We're here.
Well, we're waiting for the ACO to transform.
He's in custody. You'll recognize him. Morning.
30, Boy Mejia in matter fixing his minimum term of imprisonment. I didn't get a hearing notice back from him, so I don't know if he wants an attorney or not.
Morning. Give me your name.
Terry Boy.
Yeah, and your last name?
Yeah.
Terry Boy is your official name or is that nickname?
Official name.
It's official name. Okay, well, thank you for being here. I don't know if you want to be here, but you're here. I am looking at this. There are several convictions here. Theft second times 2 and robbery second times 1. How old are you, sir?
I am in my 40s.
Okay. Yeah. Do you have an attorney today? These are very serious charges. Are you well aware you could get up to 10 years? Or you have been given 10 years?
Yeah, I did this before, so I think go forward today.
So you think you could do it before? You understand that about 99% of the people that show up have attorneys. And even if you may not want an attorney, you can have a standby attorney. Do you know what that is?
No, not really.
Who is your attorney in the court in front of the judge?
I forgot already.
You forgot already. Was there an attorney?
Yeah, there was an attorney.
Okay. Is your mind clear today?
Yes.
Are you taking any medicine of any kind?
No.
And I take it you weren't looking forward to this hearing, right?
No.
What is this board doing today? What is our role?
Our
job?
I just gotta figure out how much time I gotta do before I get paroled out.
You got to figure out how much time you want to do. Well, right now you're sentenced to 10 years and 2 5-year minimums. You understand that? These convictions were in 2020, I guess. No, he maxed out. Excuse me. Thank you, Chair. I'm a slow study here. You got a 10-year term in 2023 and you're doing it in 2032. Do you want to stay until 2032? Or would you rather do some programs and get out early?
I know what, might be a better idea if I get an attorney so I can figure out what I can do with my life.
Well, there's an old, you didn't go to law school, did you?
No.
How much education you had? I'm not putting you down. I just want to know.
I got my GED.
Good for you. And where were you born? In this island or a different place?
Over here. Yeah.
Where's over here mean? What neighborhood?
Kapolei.
Good. Well, good place. New second city. So our job today, the three of us, is to figure out, well, number one, do you need an attorney? And you say maybe you should get one. Whoever your attorney is, you get appointed ones. If you're appointed one, it comes off of court list or the public defender. Did you have a public defender before?
I believe so.
You believe so? Okay. Were you comfortable with that person or you're not comfortable?
I feel like they didn't do anything for me anyways.
They didn't do anything for you. Did you go to trial or did you plead this out? Did you plead guilty or were you found guilty after trial? Or do you remember?
Oh, I forgot already.
You forgot already? Okay. Well, we want to be fair. You understand what I mean? We're not trying to punish anybody. We're not trying to cut anybody unnecessary slack. We got to do what's right. We have rules and three of us may ask questions. And you say, How old do you say you are?
I'm at 40.
40, about 40, and you have a GED. Any kind of job experience?
I work construction.
You work at Good Freedom. So you would like we can't do it we can't give you an attorney. We can give you an attorney, but we can't have your attorney talk to you and make a presentation. You would want a continuance.
Yeah.
Jesse, what is the normal continuance in a case like this?
2 months.
2 months. 2 month continuance, okay with you?
Yeah, that's good with me.
Okay, and you're at Halava now?
Yes.
In high security? What's your classification?
All close custody.
Okay. Members of the board.
Yeah, so, Terry Boy, you were admitted back in September on the criminal number 21059, probation revocation, yeah?
Mhm.
So you're previously on probation. Okay. Now, I think it's a smart move to get an attorney because you had the probation revocation, you got prior convictions, the new one is for Class B robbery. Yeah. And the rap sheet doesn't look good. We have your PSI here. You haven't been doing very well. So to me, it would be a smarter move to have an attorney who could best represent your legal arguments and position. Because if you wanted to proceed today, the board could go 10 out of 10 on you. You realize that?
Yes. Now I do.
Okay. See?
Yeah, I agree with your choice. There are a number of factors when you look at your history that the board could use. And I think it would be to your benefit to have an attorney here to represent your interests in the matter. You have 2 prior convictions and now you're facing a 10-4 robbery. So having spent at least a year in custody on the prior charges, that kind of elevates the choices that we have. So it's a good choice to make.
Yeah, 2 months. Yeah, we'll continue it there. Is that okay, Mr. Chair? For Concur, in 2 months. Gene, we'll continue 2 months. Get your attorney, tell them what you want, and hopefully you'll get what you want. It's up to us. And you, any questions?
No, all good.
Thank you, Terry Boyd.
Well, Terry Boy, just one last thing. While you're waiting, don't get hooked up with the gang. Don't get any misconducts because they'll only hurt you.
Okay, I'll try.
Thank you.
Your write-up has gang affiliation. You know that South Side Mob. You saw that?
Correct.
All right. So don't do it. Thank you. You may go.
Thank you.
Question.
So it's typical that we'll have people come in saying they can go pro se or without an attorney, and sometimes you have to talk them out of it. But there's very few that will want to proceed anyway, even if we read them their rights and we explain some of the history and records that could go against them. They still want to proceed, but that's small and few and in between. But the greater majority will opt to get an attorney, whether it's going to be public defender or court appointed. We'll come back at least with an attorney to help represent their case.
And even with a standby, if nothing else, if they're really a knucklehead, they may agree to a standby.
So once the proceeding pro se in front of you guys, are they generally the ones who have already gone pro se at court or?
So we usually have representation in court and sentencing, but when they get admitted, if they spend a few months in the prison, guys will say, yeah, you don't need a lawyer. Why get a rent a lawyer and this kind of stuff? You can do it. I did it by myself, and they give all the yaya and say, oh, okay, so brother wants to make big body and be with the boys, and they'll go like that.
Kevin, that's a real good question. They get threatened. They're told to have tattoos. They've been recruited into the gang. And some of them say, do you know what this place is really like, Judge Mike? And I say, I've never been in there other than sitting in for, and they tell me about it. They're usually not supposed to say that because then the guards will hear it and tell the other guys. It's a very intimidating, Mike Wilson calls it the trauma machine. They have been dropped like into a meat grinder. And that's what some perceive. Others can do it, walk in the park.
No, I understand. I just.
Bill, you disagree with what I
That
said?
shows up in terms of their gang affiliation, shoes up in terms, oftentimes in terms of what.
Oh, yeah.
Only based on the past history, if it's brought up, but generally at minimums, we may not have a hint of it. So we may give out that warning, yeah.
Terry, go ahead, tattoos.
Yeah, I saw the Southside Dreamer and tattoos in the PSI. I just want to point out too for some of our friends here on page 4 of the pre-sentence report in that under victim statement, the second paragraph. This is typically what we see on February 3rd, 2022. Responses were received from victim so-and-so and victim so-and-so. Both indicated that they either wanted to make a statement or provide a written victim impact statement. Fairly common. And the reach out is made. And I understand that there are various reasons why they don't want to do it. But again, I reiterate that when we do have a victim impact statement, that is helpful. The other thing I wanted to point on, maybe, you know, if you look at the defendant's statement, and I don't know if this is the type, but the last paragraph of the defendant's statement in the PSI, it says that the defendant related that he will do well on probation, as he will do anything to ruin the structure of the program. Was that something you guys would ask about, like in terms of programming? Like, what does that mean? You're going to ruin the structure of the program?
Well, we may, if we see it,
Right.
as individuals before, we say, this is what we have on the PSI. What did you mean by that?
Right. Oh, good. Oh, thank you.
We do catch things on state.
Yeah.
Right. Okay, thank you.
Ben?
Yeah, this, again, mainly to misinform people. So if a person does decide, isn't dissuaded, goes ahead and does the minimum, how do they get judicial review? How do they get judicial review to see if that colloquy was adequate? See what happens here? How do you get this back in front of the judge to see, well, maybe they should have had the attorney, who knows, right? I mean,
It doesn't.
no judicial review.
Would have to be under 40.
Yeah.
That'd be the only method.
Right, so they would have to write it up themselves
Yeah.
and submit it to the court.
Mhm. But as a whole, we still try to be fair.
Right,
And listen to whatever facts, review the PSI documents, any RAD. Sometimes they refuse to do the RAD, you know, and we have no relevant or good IPP for it. So we just have to go as best as we can. But sometimes it's better to set it high in case we do appeal it, and based on Fukusaku, we cannot go higher than previously set minimum. So better we go higher and then come back lower. If there is a Rule 40 and, you know, normally if a Rule 40's file goes to the Attorney General's office, they'll review it and say, you want to rehear it or you want to proceed? If there's no good arguments, then we'll just rehear the case again.
and just so that I mean, I understand what you're saying, but just so we're clear, the Rule 40 actually is submitted to the judge, who's sentenced usually, right?
Yes.
And then while the judge is looking at that conversation between you guys and the AG representing you guys.
Yeah.
Said maybe we cut it off in the past by
Right.
having a new hearing altogether, dispensing with the need for judicial.
Exactly.
Ben, one thing I worry, sorry, I'll get to you in a minute. One thing I worry about are the Rob 2s that are in California, they're wobblers.
Right.
Could be a misdemeanor with an attitude, because it could be of shoplifting. In this case, with a box cutter, that's a bad deal. But it could be just slap the hand or fight the person off.
ACO tried to grab me and I pulled my hand or shoved it.
Exactly.
Or the
It's the way out.
elbow.
The way over on
And the guy could be a crazed jerk and not deserve the 10 years, but they just should get something. So those cases really worry me.
Right.
Steve may have different insight.
But it's stupid, but it happened, right?
You're right.
Or in a recent case, they wanted to fight the LPO.
Mhm.
You know? I mean, it's,
You had a question?
Yeah, just to be clear then, so the defense counsel or prosecutor who are in the trial process don't follow the defendant to the parole hearings through. It could be a new PD defense counsel or prosecutor each time.
In our office, the rule is that if you do the sentencing, you do the minimum here because you know the case the best. Okay, so I would say most of the times, the attorney who was attached to the case or assigned to the case originally does the memo. But there are cases that come in, say the guy gets transferred from a run into a walk-through and, you know, blah, blah, blah. Then, in Hawaii, our appeals department will have to take all coverage, whether it's an attorney or say
the attorney died or the attorney retired or whatever, we'll get all the.
And we looked at the policies and I made it mandatory for you to go, it's your case to go or submit a letter. And at the same time, we ended it there and they are prohibited from going to parole hearings. That's not their crucial. They just argue the minimums, re-argue the minimums. The paroling authority pays no attention to them. So,
And sometimes on rehearing, they're not happy with the attorney, so they fire the attorney and then they get a real lawyer, you know? But we have seen so many different combinations that it's just too numerous to.
Can I just say, I'm a former public defender and sitting on the First Circuit bench for as long as I have. Former public defenders are the best lawyers.
10-4?
I agree.
I agree. We even submitted support.
Yeah. In fact, I often shake my head when people want to fire their public defender and hire different attorneys because they don't understand the experience that they're public defender.
Well, that's the jail yard talk,
Right.
But we find that the public defenders dedicated, do a very thorough job, and we're not no complaint.
One of the footnotes, Kevin, that I have keep raising, and Steve and I did this together. I didn't like the no contest pleas. And I tried not to allow, I had to do it in my discretion, but the Supreme Court frowned on it if we wouldn't allow them, so we have to use our discretion. But then it makes it real hard to sentence. And when later on they say, I had this crummy public defender, they forced me to do it. I didn't know what I was doing. I didn't know, that's, you know what I mean? That, to me, that's a giant problem. Steve and I are in sync on that one, right? Because it means no accountability.
I take no contest pleas, and sometimes even when I take no contest pleas pursuant to State versus Marino, I don't insist on a factual basis because you can't.
Yeah.
But you're right. It's not helpful when folks go up to sentencing and they say I didn't do anything, and or they're saying I just pled because I was forced to do that, right? And so as often as I can, I remind the defendants that if you are going to plead, then you better be taking responsibility. Because I'm not going to go forward with sentencing if you plead no contest and you show up and say I didn't do it, because then there is no responsibility.
But sometimes I tell them I'm going to be harder on you if you plead no contest than if you suck it up and admit it, because that's the athlete's problem. You got to be subject.
What's the point of the 253-1 under by statutes? Contest.
53 is different. That's you can have a deferred acceptance of a guilty plea as well. But the rules of penal procedure allow for no contest pleas. The Supreme Court has been clear that we can take no contest pleas, and in those situations, we don't have to take a factual basis. And I follow that, but I'm very clear with people that if you're going to plead and we get to sentencing and you're going to show up and say you didn't do it, we're not proceeding with sentencing. I'll invite you to withdraw your plea, but I'm not going to sentence you. You're not going to take any level of responsibility.
Right, but with a no contest plea, they're not taking responsibility and they're not going to say it in almost all cases.
That's not true.
Well,
That's not
that
been my
certainly was
experience.
my experience.
And the other thing too, yeah.
They're pleading out and going to jail or going to be a sentence. That's taking responsibility.
No, they are. And what the problems that I heard at the beginning.
A moralistic condition versus what the reality is.
All right.
That's absolutely not. But the problem was that when they go to treatment, when they pled no contest, they go in there and say, I didn't hit her. I didn't do anything. I never admitted to it. My attorney told me plead no contest. You don't have to say anything. And that's true in sex offender treatment. That's true in domestic violence. That's absolutely true. They're not
purposes of the board. This is what you're convicted for. This is what you came into prison for. Whether you pled guilty, no contest, or whatever, we'll take the offense that you were admitted for. Bottom line. Martha.
Okay, thank you. Thank you. So I want to thank you, Judge, for pointing out that each statement and saying how important it is to you. And also for bringing up the issue of judge count, because I'm wondering if in fact it is that important. Is the letter reviewed and are the contacts made that are really trauma informed because the victim has been through the most, no doubt, traumatic event of their life. And so you're not going to necessarily get a response by just an easy, quick letter, or if there's no relationship, or if perceived the relationship as somehow the person talking to them is with the defendant, whether that's accurate or not. And I get that. So I'm wondering if there's a way to try to be more encouraging for victims to participate, both at, now with PSI, but also in the minimum. I know that would probably take more time, but it sounds pretty important because what we know is that trauma-informed training is going to be really important for that outreach to the person if you're going to get something in, because they're nervous about what this is really about.
Sure, both parties, be advised, both parties are nervous, whether it's the inmate and sentencing and in court. Because some of them, they plead out, they don't know what the hell they're pleading out to. By the same token, you have victims who come in who are still reliving trauma. And one of the things that is my issue with here, minimum hearings, is some of these hearings, we can do it 6 months, sometimes it's a couple of years down the road. Some of them on a rehearing is 10 years down the road. And the victim witness still comes in having to relive the event and the trauma and everything else. So that's one of my issues with rehearing and victims and trauma, you know, but it is what it is at this point. And hopefully in the task force, we can address some of that.
Right here.
Oh, Dennis?
Thank you. I just wanted to provide a little more perspective on that because I did do some surveys and I've worked with a number of victims who've been to the parole minimum hearings, and most of them find them to be very supportive, in part for some of the reasons we've already talked about, because they feel that they really have a voice and feel more comfortable participating. But it often is very healing for them to hear the members of the paroling authority holding the person responsible, making them take responsibility. And they often say that they see that at the parole minimum hearings, but not at the sentencings in court. And that a lot of them contrasted their experiences, including one just recently that was brought to my attention. A specific woman in the domestic violence case that said that she thought that the board was very supportive and that it was very healing for her to hear the board work against efforts of the offender to try to act like they didn't really do anything or not take responsibility. And that was very helpful for her and her healing to hear that.
Andrew, last one before we move on.
Yeah, just to I think to your point of, you know, how do we encourage or bring about more victim participation? And I think that falls on Dennis, on a point. I know you're retired, but I mean it falls on us, right? The prosecutor's offices and the victim witness services, and not necessarily to encourage, but to help them feel, number one, informed and supported, so that they know if this is a process they want to undertake, that this is what they understand what that process will be like. And they know that there'll be someone there to support them through that process, right? So I don't know that it necessarily falls on the board, because I think the board does everything to accommodate victims as best they can. It really falls on us as the prosecutors and our victim witness divisions to be there for the victims, to have a trauma-informed, victim-centered approach so that we can, because it is, you go in, you know, especially if you're in a facility, but to take a victim into that environment and the person sitting right there, right?
You're right.
So the feedback I get is they feel safer at the prison than they did at court.
And that's troubling to me to hear that. You know, I would hope that whenever victims come to court, that whatever judge is presiding over sentencing would thank them for being there, make them feel welcome, and make them feel heard. I think that's a critical step in that process. I really, really do.
I agree wholeheartedly.
Yeah, I really do. And it saddens me and I guess a little bit shocks me that that's not.
The impression I've got is they're trying to be, they feel the judges are trying to be more fair-handed, you know, more objective in approaching the sentencing than at the parole level. The person's already convicted.
Right.
Already
It's a different type of hearing.
Yeah, and I think that's really the difference.
And there are judges that do it, and the feedback from the victims is that it's just incredibly valuable.
But Kevin, I think some of it, they're afraid of retaliation. You're in an open court setting. I would do all I could I mean, if I could take off the robe and look at him, find it, all I could just say, I want to hear from you.
Yeah.
This is your only and possibly last chance. Who else do you need here to go through this whole empathy criterion?
Right.
And I think judges probably need a little more training on that to sure.
You know, and the other thing I'm very cognizant of is I can control what happens in my courtroom.
Right.
The security of my courtroom, and even in the hallways outside of my courtroom. But if people feel threatened, you know, walking to their car or leaving the courthouse, that's a vulnerability I think that I can't do anything about.
There is parking lot violence. I've seen it.
There is.
And I hate it.
And so, I mean, to the extent that that's keeping people away,
You're right.
I wish we could do something about it, or something more about it.
And in one case, Judge Town actually called me at my office and told me to come to court and pick up the victim and give her a ride home.
Yeah.
To make sure that she felt safe.
Well, as a former family court,
That was pretty cool.
at the TRO hearing,
I'm calling you
people
Uber
would
now.
leave the courthouse and we'd walk out to the parking lot in Kapolei and their car would be there,
Yeah.
right? And
I've seen
you
it
know,
all.
we need to have safety plans in this.
Jesse?
Okay. Case number 32, Charles Rankin, matter of fixing his minimum term of imprisonment. He is represented by Phyllis Hernaka. Also present is prosecutor Stephen Long.
Hey, Mr. Rankin, good morning.
Are we on record, sir?
We are on record.
I want all these people out of here. They have nothing to do with my case.
That's not for you to decide. We're here to set your minimum today. Are you ready to go forward?
Sure.
All right, so November of 23, you were admitted for 3 offenses. Kidnapping with an open 10, murder in the first degree with an open 10, and murder in the second degree, which is life with the possibility of parole. So we are first going to hear from Mr. Ohm, and then we're going to hear from your attorney, and then we'd like to hear from you as to your involvement in each one of these offenses.
I just want to note that the previous board action sheet says he was admitted September 7th, 2023.
Okay, noted. Thank you.
All right, thank you. I'll just summarize here. You know, the state is going to recommend that this inmate be treated as a level 3 offender and subject to a minimum of 50 years of incarceration. He was convicted of murdering by stabbing, drowning, kidnapping, burglarizing, an unauthorized entry, and strangling the victim. It shows a callous and disregard for the safety and welfare of others and demonstrates the extent of his criminal attitude. And the court is in, the board is in a very good position to judge his attitude, both in this hearing and otherwise. He first stabbed the victim. He dragged her into the waters of Wavy Beach. It was a domestic violence relationship. She was kidnapped with a knife, broke into the residence, and it caused the victim to flee when other family members woke up. And there was an opportunity, I think the defense tried to say there was extreme emotional distress for which there's a reasonable explanation that was rejected by the jury. And so I think the evidence showed it was deliberate, it was intentional, and he had coaxed the victim into meeting with him. He took her phone and promised to give her back. You know, that shows it was premeditated, it was clearly thought through. And so I think a really severe minimum, like 50 years, is appropriate. Thank you.
Okay, thank you, Mr.
Okay, first of all, I would like to make some corrections. I think the prosecutor misspoke on a number of bases. We're actually here for a minimum on 2 different cases. And there were 2 different victims, to my understanding, in this case. And I'm going to kind of run through like a brief time frame of this as I understand it based on the information I have in front of me. First of all, it lists on the PSI that I was the assigned public defender, which I was not. And I would have much more information about this case if I were the assigned public defender, because of course I would have read the police reports, etc., and spoken to my client at greater length than I have had and prepared for this minimum hearing. But based on what I have here, there were 2 complainants in this case. One was the defendant's ex-girlfriend. And that's where the kidnapping and the burglary in the first degree case came from. Because again, based on what I can see, in December of 2017, like December 30th, that was the incident that the prosecutor described about taking the girlfriend's telephone and then requiring her to come to pick it up. And there was a kidnapping there because then there was some alleged allegation of a knife held to the breast and a threat to kill. Then the following day, December 31, 2017, the information that I have says the defendant entered the female's residence, jumped on her, began choking her, and that's where the relatives chased the defendant off of the home, as the prosecutor just spoke of. So that's the burglary. Then what happened is that in January, I'm going to say around the 1st or the 2nd of January 2018, because on the 3rd, the body of a 20-year-old male was discovered on the beach at Nanakuli. Police identified the victim, and this is a male person, okay? And the information was that the defendant was seen walking with the victim on New Year's Day. That would be January 1st, 2018. So the murder arises out of this other person, the male. My understanding of the court proceeding is that the 3 offenses were originally charged in the one charge. The murder was later not only prosecuted or dismissed, and that that with just the 2 remaining charges, the kidnapping and the burglary, the defendant pled no contest to those charges. Subsequently, the murder was re-indicted, and so it has a separate criminal number, even though it's related to the original offenses. So I wanted to set that straight.
Quick question, Counsel.
Yes.
So you mentioned earlier that you were not his attorney?
No, because I would know, I was not his attorney throughout the trial proceedings because I would know a lot more information. I came on board to this afterwards. The other thing is that I believe the prosecutor misspoke again in saying that he went to trial on the murder. He did, but he had a bench trial, a judge trial. So it was not a jury verdict of guilt.
Okay, so have you discussed these matters with your client? Are you prepared to go forward today?
We are prepared to go forward, yes.
Okay. And you've met with your client?
Yes.
Okay. All right. Go ahead.
Okay. With respect to, first of all, I think that I'm going to take the position that the prosecutor's request for a 50-year minimum for this offense is exceedingly high. My client, Mr. Renke, is 44 years old. If he gets a 50-year minimum from this board and he's put in, 5 years, let's say, then he would be, I have to do the math on this, which is terrible, but he'd be in his 90s when he first comes up from parole. So essentially, this would be a life sentence without parole. It is a life sentence without parole, okay? Which I think is completely unfair because it gives the defendant no incentive to rehabilitate. It gives the defendant no incentive to participate in programs and to show that he can be a law-abiding citizen within the community. This man, according to the police reports, has no history of probation, parole, or incarceration. And in fact, his arrests in these cases were his first arrests in his life. So this gentleman was able to live a law-abiding life for 40 years before this incident happened. It appears to me, and you're going to have to ask my client for confirmation of that this was a love triangle kind of a thing. He had been with this woman, the female, for a period of time. They broke up. She started dating this other person who was the murder victim in this case, and that he basically lost it, and he was obviously unhappy about this outcome, and that's how this arose. But never before in his life was he in trouble. He not even as a juvenile did he get arrested for anything. And it's specific to this particular set of circumstances. So yes, I know from the board is concerned about public safety, and they may be concerned that, what if he gets into another relationship in the future, et cetera. We need to protect society from that, et cetera. But again, with those considerations in mind, and taking into consideration my client's current age and the fact that he has no prior history, I believe that a 50-year minimum is way out of the ballpark too high. Let me go through the factors again that the board considers on its matrix in setting a minimum. Nature of the offense. I would concede that this is either a level 2 or a level 3 offense. There was a substantial disregard for the safety and welfare of 2 other people because there were multiple counts involved. That's level 2. Level 3 is that the prosecutor characterizes it as a callous and cruel disregard for safety and welfare of others. I don't believe that it was callous or cruel, just obviously in a fit of rage and anger over the circumstances in which he found himself in. None of the other factors, such as drug manufacture or offense against a handicapped person or a minor, et cetera, that would make this nature of the offense a level 3 come into play. With respect to the criteria of degree of injury or loss to person, I would say that it's comparable to those experienced by similarly situated victims. In many domestic violence situations where the spurned boyfriend breaks into the ex-girlfriend's house, it's just a standard house break-in. Yes, there was the strangling incident that the family members scared him off of or whatever, but it's not any more outrageous or egregious than a typical break-in. As to the murder, when somebody is stabbed, obviously they're in a lot of pain. In this case, it included the autopsy said it was loss of life by drowning as well, so it was a stab and a drowning. Again, I would say that the complainant died, unfortunately, but that's I don't want to sound callous by being standard, but when somebody dies with a murder count, that is the end result. Okay. Criminal history, he's definitely a level 1 because he has no prior criminal history, definitely not a level 2 or 3. Character and attitude regarding criminal activity or lifestyle. Again, I would say unlikely that's a level 1 because he has never been in trouble before. And although, yes, he did get convicted of committing a heinous crime in this case, that being murder, there is no indication that I can see in his track record of his life lived up to this point of somebody who's like a recidivist and, would be a threat to the community. Same thing with efforts to live pro-social before prison. He's a level 1. He has not gotten into any criminal trouble. It's quite likely that he will be able to live under full supervision. He's not a level 2 and certainly not a level 3. Probation revocation doesn't apply to him because he was never on probation. Young adult offender also does not apply. Involvement of the offender in the instant offense would be a level 2 or a level 3 because he was the only perpetrator in this offense, didn't involve any other people. With respect to the additional criteria, none of them apply except for the diminished responsibility. And question mark as to whether degree of provocation by the victim, that being the decedent, whether he or even the girlfriend contributed to any of this. And I know the prosecutor would disagree with me with respect to that based on the information that they have. However, that would be something that the board would have to make a decision on. So with respect to all of the criteria that I that the board considers in fashioning its minimum. I would say that my client should be probably a level 2 as a balance between quite a number of level 1 criteria and some level 3 criteria. And that 50 years is, again, as I said, way too high. My client is planning on appealing the murder in the second degree charge. So that's the third offense, the second case. And so I've advised him not to speak to the board to answer any questions with respect to what happened in that case, because that's going to go up on appeal. And if he's successful, of course, he may get into trial. And I don't want anything he says to this board to later impact him at that subsequent possibility. With respect to the kidnapping and the burglary, the first case, he pled no contest to those cases. So he is facing the minimum on that case. And we, the board can question him. However, since the two cases are really kind of bound together, and the circumstances of what happened in the kidnapping or the burglary are related both in time as well as persons to the offense of the murder in the second degree, my client may choose not to discuss those either, because again, as the board is now aware, that since the murder case will be on appeal or is on appeal, he may not wish to speak about any of those. So that's my position with respect to my representation of Mr. Ray.
Okay, so let me be clear on what you're saying. You're advising or saying that your client will speak to the kidnapping and burglary.
He can't be asked questions. I don't
But
have.
he will not speak as to the murder in the second degree.
That's my legal position, yes. But because those cases are interrelated, okay, he may decide that it's in his best interest not to speak to any of them, because they're, even though he understands that he's convicted of the kidnapping and the burglary, they're related to the one that's on appeal.
Okay. So is it your intent to go forward?
Yes.
Set it to the minimum in all three?
No. Certainly not in the murder.
For the burglary and kidnapping.
The burglary and the kidnapping are free, if you will,
Okay.
because there's nothing further to be argued in those cases. But as I said, since they are together, it may be in the board's best interest as well as my client's best interest, as I'm kind of thinking this through here, to postpone the minimum hearing altogether until that murder case is decided. Because if, say, for example, in the best of all worlds, he gets a new trial or something and say, I don't know, beats the murder charge or, comes out to manslaughter or something, then it's a different set of arguments that we'd be making here at this minimum. And since those two cases are tied together, it would be prejudicial to my client to have a minimum set on his kidnapping and his burg charge that, say, possibly is higher than the one set for, say, a manslaughter conviction with respect to that murder case. That's as I'm thinking this through, that's my position.
Okay, understood. Mr. Renke, you follow the conversation here?
Yes, sir.
Right. What would you like to do?
I'm not going to say anything. The judge was ridiculous with the sentence, so I'm going to appeal my case. My previous attorneys were bullshit, so I'm not going to answer any of your questions.
Okay, so I understand the appeal is in the murder case.
Yes.
Okay. So can you talk to us about the kidnapping and the burglary case?
I'm not going to answer any of your questions.
Okay, so you understand that we're not going to have any input from you when the board determines minimum sentences for these offenses. We're going to rely on what we have in terms of the documentation. You heard the prosecutor's input into the case. We have the pre-sentence investigation that has the offense information. And without your input, then the board will rely on our documentation. Is that your understanding?
May I interrupt? a minute, which is that I think I'm going to underscore my position that this hearing should probably be continued in toto. That being that the minimum for both the kidnapping and the burn, as well as the murder or whatever the case on appeal, should not proceed at this point. If they were unrelated cases, that would make sense. Yeah, you can go ahead and set a minimum on the kidnapping and the burn. But since they are related, factually, etc., I think that it should wait until that last piece is resolved.
Okay, so Mr. Renke, that's the advice from your attorney, to continue the matter where we can do all three at the same time.
Like I said, I'm not gonna answer any of your questions.
Can I ask something?
Go ahead.
Counsel, the murder case was a jury trial?
No, judge trial.
Judge trial, okay. So that means he had to knowingly, intelligently, and voluntarily waive the jury trial. It's not the prosecutor's call. It was his own, right?
It had to be, yes.
Right, Mr. Rinke? You went with the judge, not with the jury.
Sorry, I'm not gonna answer you.
Okay, no, I'm just gonna say it so you hear it. We're one of 10 out of 200 countries in the world that allow citizen jurors to decide guilt or innocence. Most people in a murder case want a jury trial. Just so you know, you don't have to answer it. I don't want you to answer it. FYI, thank you.
So, Mr. Rankin, what did you find was so bullshit in the process?
Again, I'm not gonna answer you guys' questions. You can make your decision, but
You
Well,
won't
we're
even,
asking for a postponement. So, yeah, they're not gonna make a decision.
so should we grant the continuance? How long are you looking at?
Well, appeals take, I would say, upwards of 2 years, and I know that's a long time. And a consideration that Mr. Renke had to make is that when he doesn't have a minimum, he is unprogrammable.
That's right.
So he will not be able to proceed with any substance abuse, whatever treatment programs are recommended for him. And that may hold him back. But on the other hand, since he's looking at a long minimum, as per the prosecutor's recommendation, he probably would not get to those programs anyway within a 2 or even 3 year period. I'm going to say probably if it went the way the prosecutor is asking, 50 years, they probably would not send him to any programs until the 40th, 50th year. And when he gets quote unquote ready for parole. So based on that, Mr. Renke really has nothing to lose by asking for, I would say, a 2 or 3 year continuance of this hearing. If the appeal goes through sooner than that, certainly his counsel can ask the board to schedule his minimum a little bit earlier.
Well, Mr. Ranky, you heard what your attorney said. It can take anywhere up to 2-3 years, and even then it might not be complete at that time. You understand?
yes,
So the board normally does not continue cases for that long a period of time. All right? Just so you know, because by your decision to postpone this matter, continue this matter until you get an outcome of your appeal, you'll just be sitting flat doing nothing, wasting time.
I'm sorry, if I could interject, he will be doing that anyway, because regardless of if you folks give him a decision now or give him a decision 5 years from now, let's say, he's still going to be doing that much time. So I understand from his position that it makes no difference. And so, from Mr. Rankin's position, that would be perfectly fine because he's going to be sitting.
So counsel, let me be clear.
Yes,
Are you appealing the conviction or are you appealing the sentence?
he's appealing the conviction, not the sentence. Well, the sentence comes from the conviction, but he said that he didn't think his attorneys did a good job, and the judge wasn't fair or something to that effect. And so he's appealing the process that got him convicted.
Mr. Rankin, is that correct?
Yes.
Okay. I would recommend 6 months in case there's a change of heart.
Okay, so Mr. Renke, we'll continue for 6 months and go from there. Thank you.
Good luck to you, sir. You may go.
So as you were talking about earlier,
Yeah.
here we have a clear case of this kind of stuff.
Pakiki.
Oh, Pakiki.
Oh, Pakiki.
What is the board's policy generally? If somebody's up on appeal, you know it's gonna take 2 years. Do you guys just sort of incrementally continue and then at some point, if it's taking too long, you guys just cut it and decide?
Well, we have had, like in the Langford case.
Yeah.
That's been going on over 12 years. And we've had other cases that just either out of it or mentally not wanting to. They got their own agenda. So 5, 10, 12 years, 15 years, we haven't been able to hold a minimum. So we do it incrementally, give them the opportunity, and nobody can come back at the board or saying just, we're going to forget about you for 10 years or even 3 years. Because things can change. They may have a change of heart. He might get tired of sitting on his buns doing nothing. But we do have them.
Can I make a comment? It's something I didn't think about. The just provided this example. Let's say the responsibility for meeting our minimum sentences does shift back to the judges. And this type of situation arises. Where I sentence someone to the statutory maximum, but then I have to start making value judgments based on certain criteria, whether it's 706, 606, or other criteria, offense variable criteria, and I set a particular minimum. And I give my reasons for this. And then the defendant appeals. And let's say the defendant is successful on appeal, the case now comes back to me, the table is reset. What is the defendant's comfort level going to be with me as the judge going forward after I've already, again, not just giving him a sentence based on, by the way, this is the statutory maximum that I have to give you based on your conviction. But now I have made as a judge certain findings about you and your behavior in setting them in. How does that, I'm just trying to think about how that.
On you, if you felt that the judge has already determined the factual conclusion and it got reversed, would it be incumbent on you to recuse yourself then? Well,
but that would have to.
It doesn't even get that far. There are about 6 or 7 published, or maybe 4 or 5 published opinions, right? 6 or 7 total, where the remedy by the appellate court is very clear. It goes back to a different judge. And so that decision was already made, at least on a resent. That's on resentencing. So I would imagine if the judge set the minimum, you'd have it'd be incumbent on attorneys like Phyllis on appeal to say this is the remedy appellate court.
So and you're right. And that is what the appellate courts have said. My only comment then is that this would be a much more common occurrence if the minimum shifted back to the judges. And again, I've already said to everybody here, I'm not taking a position one way or another on that. I've said that I think that there are legal complications based on a lien considered a lien, the Supreme Court case a lien, that those considerations, we as judges start making value judgments, offense variable judgments, without jury findings of the defendant stipulated. But I'm just pointing that out as something that I think this committee needs to consider, because it would start happening more often in these very situations. Well, if we had to, judges have.
Fred, I got some. Go ahead. I was struck in a positive way with your office, because the job of a prosecutor under State versus Wong, which is my case, is to be a minister of justice, not just an advocate, was to be a quasi-judicial officer, not just a judge. And my instinct, I'm glad you raised it, because I'm thinking out loud, which is scary. I would put it back on the prosecutor and instruct them. So they have these different roles. And Andrew, you just put out a really good forgive me, I do read Facebook. And your attorneys,
With LinkedIn.
you're recruiting. The attorneys have to, if a person's not guilty, you tell me as a prosecutor. If the sentence is egregious and awful, you tell me. And if something else happened, you tell me as a minister of justice. So I would want to put that monkey on the prosecutor's back and brief it. And maybe Ben's right that we got to go get another judge. Watch out what you wish for.
Well, I'm just saying, in a resentencing situation, it's built in the order and in the opinions.
Don't you need another judge?
They remanded to a new judge.
See, I learned something today. I haven't been a judge for 12 years.
Goes back to David Shutter.
Well, David Shutter is sui generis because he got real rude with Dickie and Wong. If you knew Dickie and Wong, you can understand two of the rudest people in the world.
Well, they gave us that.
That's bad precedent when that happens.
So what about in your retrial?
Right, because this is not just a resentence, this is a retrial.
Well, retrial, you may not get the sentencing. That's the theory behind that. It's just remanding for resentencing. There's been the conviction, they uphold the conviction and they send it down. That's what happened.
But if there is a retrial, that said, there's also always the option that the defendants may want to waive jury, and then you're dealing again with the judge who's already.
This case was a waived jury, so it would go back as a waived jury, right? So.
Well, that's up to the defense. They can exercise their right to a jury.
So this is a good discussion, and the reason why this whole concurrent resolution came out. So just a quick history. About 2 years ago, Rep. Takayama called and said he wanted to address minimums again because it keeps on coming up. I said, fine, let's put it all on the table because HB is tired of hearing all this nitpicking BS. Let's put it on the table, have a forum, go for it. So he broke it to Lynn Kowano. Lynn Kowano did her story. I shot it over to Gray, and he formed a concurrent resolution. And this is exactly why, and what we wanted to accomplish is the dialogue, all these little nuances and little nitpicky stuff, so that the task force can make a proper recommendation to the legislature for an adequate or relevant with the current times and the current laws. Because otherwise, if it was to revert back to the judiciary, there'd be statutory changes, admin rule changes, and who God knows what else is going to happen. But this form is that.
It would have to come, in my opinion, with a complete overhaul of Chapter 76.
Mhm.
And the entire restructuring of the sentence.
Yeah.
It would have to. And I mean, I can detail my reason why, but I'm not.
Yeah. But I mean, that's, like I said, exactly why, we have this forum and why too, stupid me, volunteered to do these mock things because it feels us a lot of work.
Thank you.
But it I think points out, although we haven't covered everything, because in 2 or 3 years, you'll never be able to cover everything for the minimum. You'll see so many different cases that Cheryl Phyllis can attest to, and the retired judge.
One of the things I would say for consideration, Judge, as well, that one of the things we need to pay attention to is if there is an agreement that changes would need to be made to Chapter 706. I think the Penal Code Review Committee, Judge, is getting started soon. And so, our work would theoretically dovetail into their work. And so that's something that we as a group need to keep an eye on.
Well, I've shared that twice, and I think the problem is you have to look at the whole penal code and move quickly. So I think it's probably going to have to be a separate group working just on that. I mean, that is such a huge lift. Like, you have to come up with guidelines and judges, the other side of it is if a person lands in a certain guideline, a judge may have to do something they don't want to do or they feel. Right now, judges have tremendous discretion about prison or probation. And if there's a set of guidelines, if they're going to follow those guidelines, they may have to send people to prison they don't want to. So, I mean, be careful of what you wish for. It is a tricky, difficult question.
Good.
Yeah, we may go from an indeterminate sentencing system to a determinate sentencing system.
And then you gotta be careful what you respond to.
Have you looked at the Florida conversation with Judge Morikawa this morning?
Yeah.
And
I'm aware, I've had that same conversation.
about the point system that Florida uses, it's been compromised.
And we've been briefed about a lot of different states and the systems that they use, and each one is different. Each one uses their own approach. And each one has taken, I would say, I don't want to be hyperbolic, but it sometimes takes a decade for these states through the process of enacting legislation, that legislation getting challenged, and ultimately coming to a conclusion as, okay, this is where we're going to land with respect to how we sentence people and still stay in conformity with Apprendi and Aline and other constitutional principles.
But Kevin, isn't some of the problem that we've departed from the public safety rehabilitation mode? We've got all these sub-3 weird laws that are policy that don't have much to do with public safety. Gambling, some drugs. I was just at the legislature yesterday. They are wrestling with the marijuana thing. Fred's weighed in on that, but what is public safety and what is the issue?
Well, thanks, Judge, but that's not my role. The legislature enacts the laws, and I enforce it as they. Well, I don't enforce it, but I follow them.
Well, I taught criminal law twice up at UH over the years, and we had the model penal code, and then we departed so dramatically from it, added in all these little sexy little things that it makes me crazy.
Right.
Crazier.
And the model penal code itself, I think, was enacted as part of a constitutional convention. I know right? And so, that process in itself.
You're right.
So I'm gonna jump into, sounds like we've had a great conversation. But I wanted to check in to see if anybody on Zoom, number one, had questions or comments, right? I just didn't want to leave our Zoom folks out.
Gelden's been waiting.
What's up, Gelden?
No.
Moko Okeawe.
Well, good to see you guys on Zoom.
Thanks for having me. I know Fred covered this earlier. He shared that he met with Rob Coleman and I about the PSIs and how it's been impacting HPA. So we did try to make some changes. One of the things that I guess the largest issues is that what we've had is they've had staffing issues at judiciary. So with probation, we waive PSI on the agreed upon probation cases with under the theory that if an open term is imposed, there'll be a resentencing report so that would be available for HPA's consideration. The issue why we still kind of want to waive PSI sometimes, it's because sometimes the agreements contemplate early release to treatment. So for a PSI on Hawaii Island, it takes about 8 weeks to turn around, 8 to 10 weeks. And there's been a number of times when we show up for sentencing, maybe a week prior, we'll get a notice saying that they need another 4 weeks to extend it because they can't get the PSI done. And as a result, between prosecutors and defense counsel, it gets negotiated out to waive PSI. So that's one concern that, getting the proper support from the judiciary for funding purposes, for positions, or however else we can work with them. I don't know if even getting a modified version of the PSI. I think, Fred, remember, we kind of talked a little bit about that with Rob, if that's something that could be discussed, because I think that might be something that might be feasible for them, given their manpower shortages. Earlier, there was some discussion about safety concerns for victims in the courtroom. Judge Souza mentioned a little bit about that. That has been something that's been echoed through our victim assistance unit. And that's one of the reasons why they prefer to have the input provided by victims at the minimum hearings, because they have safety concerns in the courtroom. And a lot of that has been because of the way certain judges run their courtrooms and the manner in which they conduct themselves. So there is an extreme level of sometimes what seems to be offender-based interest. And that is very discouraging sometimes for victims, because they come into the courtroom setting and they feel like there's more of a focus on the offender versus them and what happened to them. And they get this feeling because they may attend a couple hearings and they feel that throughout the process. So I'll give you an example. There is a particular circuit court judge who oftentimes engages with individuals who are seated in the gallery during proceedings. And it might be a custody setting hearing or, for purposes of, they'll ask for input from members in the gallery regarding the custody status or bail conditions of the defendant. And they'll call people up, sometimes siblings, children, or worst case scenario, the victim of a domestic violence incident. And as a result of that type of situation, it does impact the case. And that kind of plays into the whole safety setting. And I think Judge Souza mentioned a little bit about, how that saddens him. It saddens us too. So, that's frustrating, but that's one of the things that has been echoed to our victim assistance unit. I'm just checking my notes to see if there's anything else.
Thank you.
One last thing. There was, I think, a number of, you guys have probably noticed there was less cases where you guys were getting from our island, but that was because during the pandemic, one of the things the Third Circuit Court judges were doing, this is more of a East Hawaii issue versus a West Hawaii issue, but there was a lot of early termination of probation cases, individuals that were revoked 3, 4, 5 times. Normally, back in the past, before the pandemic hit, on a third level, you would likely see an open term imposed. During the pandemic, there was a shift, and a number of individuals were resentenced to a new term of probation and a straight jail term, and then they were their probation terms were then terminated. As a result, a lot of those offenders are now coming back through the system with new cases. So we're still struggling a little bit with the overcrowding issue. I know Kristen's there. I'm sure she has that everyone very well aware of what's happening at HCCC. The new wing is set to open soon, but we still have those overcrowding concerns that impact a lot of our the way that the system runs here, as far as not having a West Hawaii facility and the transports daily. So all those things impact how the criminal justice system works here on our island. It's very unique and different, but I'm here if you guys have any other questions. Thanks for the opportunity to share. Mahalo.
Thank you.
Thank you so much, Keldon. We always appreciate hearing you and your thoughts. I know that we had 2 breaks scheduled in our agenda, which we did not utilize at all. But if it's okay with you, so we have one last presentation. It's pretty short. The intention of the presentation is for Erin to kind of highlight the research that she's been working on for the task force, and then open it up for questions. If people want to talk about, what she's looking into, her methods, et cetera, et cetera. Maybe we can take a 5-minute, I know it's so short, and then Erin can do her presentation and we can call it a day. But thank you so much to Fred and the parole board, and just, we really.
Leave your box at the front of the table and we'll pick them all up.
Oh, talk to her. No, I'm not leaving.
Are you saying?
Yeah, stick around. But we have our ukulele this afternoon.
It doesn't matter.
I can bring a chair here.
Oh,
Were you just tell me where this?
okay. Oh, yeah, drop it to be like.
You got it.
My favorite are the mango licorice. So Aaron, whenever you're ready. Everybody, I'm gonna ask you to grab your seat so we can
All right.
try to get out of here on time. I think we can do it.
I think
We're
so.
determined. Pull that talk to me about it. I don't know. I'm gonna be brief, but I can do it.
Yeah, so that's 40 years.
I was talking about his wife.
He married her 40 years ago, almost 40 years ago.
Competent.
Take it away, Aaron. Okay. I have to say it's kind of hard to follow that because that was really great. And also it's almost lunchtime. And anytime you hear data, sometimes people already are like, oh, here we go. But yeah, so I was just going to try to do a big picture overview of the data and the research questions for the task force. So, well, you can go next slide. Yeah, so as you know, Council State Governance Justice Center is providing technical assistance, and we have Carl Separate over there, and one of the researchers is online, Angie. And then, of course, the Oversight Commission, and then I'm the director of the Criminal Justice Research Institute, and we're also mentioned in the resolution as providing assistance to this task force. So I thought I'd just really quickly kind of explain how we sort of teamed up on this approach to clarify what we're doing. So with the Oversight Commission, they're chairing this and really helping set priorities with the task force to ensure it meets, the expectations of the legislature. And a lot of that is really helping us prioritize, I think, the research questions, because listening to all these discussions, I think everyone probably has a million things that we could ask, but we can't do it all, especially in time to finish the task force. So the commission, will help ensure we stay on track and really prioritize the questions that we need to prioritize. With the thing that we're doing, me and my staff, is helping kind of look at the data landscape and figure out what data is out across the system and helping collect that to conduct analyses. So with our work, we're pretty immersed in the different criminal justice agencies' data landscape and understanding what's collected and how it's used and what kind of reports you can produce and what kind of reports you can't produce. So we're trying to kind of lead the effort on the ground to compile the data and the information that's needed to answer relevant research questions. And then the Council State Government's Justice Center is providing research support as well to analyze, conduct the actual data analysis. And then also kind of all of us can really brainstorm and get really strategize about what research questions we ask to bring information to the task force that will really help inform these discussions using data that we have. So the data systems or the data collection that we targeted so far is, so I'll start with a couple of things. So there's criminal history information that we can use. So it's the criminal justice information system. Basically, you can understand someone's prior criminal history, prior convictions. And so we know that criminal history plays a huge role in a lot of criminal justice decisions. So that is a really reliable source of that information. And fortunately, an electronic source that we can really easily work with. So we are collecting some data from there. Another source that we're using is data from the Department of Corrections and Rehabilitation, because as people enter and exit the institutions to serve time or sentences, we have some basic information from there that we can pull from. But of course, the drawbacks to both those systems is they're not HPA's data system and not really capturing the decisions of HPA when they set minimum terms.
So with the data in terms of that we're really trying to focus on is minimum term data and information about the decisions around minimum terms made by the HPA board members. And so unfortunately with their system, we can't really extract electronic data sets that you sometimes can use. But it does have a lot of helpful information about what board members are doing with the hearing. So actually, I think this discussion is really timely because we all just saw some examples of what that looks like and the different factors that are reviewed in the files and histories to make these decisions, and that there's guidelines that are followed and tracked. So that information, we can't really get an electronic form of that, which means we have to spend more time upfront manually collecting that. So actually reading paper files to go through and collect that information and categorize that. So with that being said, we're kind of pulling from these different sources, and we're kind of taking some different approaches. It might depend a little bit on what is the research question. Certain data sources might be better for others. So trying to kind of put those puzzle pieces together. And then, one challenge is, again, without having an electronic data set. So there's not like a spreadsheet, for example, anyone can send about the minimum term decisions in the more nuanced or detailed fashion that we might want. We're kind of limited in how much data we can collect there because it requires kind of full days on site to do that. And I don't think we can do months of data collection like that, but we can certainly do enough and do a snapshot and use some statistical techniques to help us generalize and give you information that's still really helpful in understanding what decisions are made and how they're made. And I also just really want to thank everyone from the different agencies who's really helped answer questions about what data is there, what they can and can't do. And particularly here at HPA, where it has been incredibly helpful helping us get set up and be efficient and really understand what we're looking at and how to use it and to ensure that we're collecting good data on that. I kind of touched on these barriers. I feel like I do my typical research. Here's my limitations, everybody, but I have to give them. And so again, one of the biggest barriers is that there's some information that is not electronic, which just means it takes a lot more time to get that information, which given the short time frame we have, will be limited in how much we can look up and use. So for example, you see that there's actually a lot of narrative kind of information that you have to read through. So if we want to create sort of a category or a variable to study that, it takes quite a bit of time to sort of read through that file and make that determination and to create that kind of data set. And then also with files or any data set, if information is missing, sometimes it can be difficult to understand if information is missing and that means it's not applicable, or is it just it's just not there and someone forgot to put it there. And that kind of impacts to how we use that information for statistical purposes. So with that being said, that's kind of one of the biggest challenges is the lack of kind of a data set to work with, but we also can use and work with some of those other data sets. And then also in this work, just very typical, each agency sort of has their own data system, their own IT infrastructure, and even in some cases, they might track information differently. So courts track by cases, but arrest records, you can search by people. So when you try to merge this information together, it can be a little time consuming to kind of put those pieces together and put the whole picture together. So those are kind of the barriers we're working with, but we're working hard to get through them and get some data collected to get to some of the key questions. The other thing I would say too, the next slide is that just, doing our due diligence as researchers to really follow rules around confidentiality of records and create data that's anonymous so no one can look up information on people, protect private information, and following those protocols as well with each of the agencies around how we store and share data. And then to the research questions. How am I doing on time? So with the research questions, what I thought I would do is just kind of discuss big picture overview, kind of broad questions, give a few examples, but then it might be easier that way to discuss at the end if there's certain questions people want to ask more about or get into more aspects of. So the first question, of course, we went back to the resolution as a team and looked through what is the purpose of this resolution, what are we focusing on, what are we studying, what kind of information to help all the task force members make informed decisions with the use of data, and narrowed it down to a couple broad questions. So the first one are just kind of what are the trends around minimum terms? So with the current HP data system, we know it's very difficult for them to pull a lot of this information to do statistics. So we do have some general picture of kind of averages over time. So what we're doing is try to build out that data a little more to get into more than just the averages. And so understand things about trends related to what factors might be related to certain minimum trends. What is the range? So what is the lowest? What is the highest? And kind of really digging into those trends over time to do that. And also kind of break down maybe information a little more closely on are there certain trends related to certain types of offenses, for example. So now we kind of see minimum trends. What is the minimum term for a specific conviction that's in HRS? So when you have all these trends or averages and all these different convictions, it's kind of hard to make sense of what we're seeing there, but we can maybe categorize some of those to say, do we see certain trends with certain violent offenses? Do we see certain trends maybe by circuit, just sort of really getting at some of those descriptive characteristics or things that might actually be related to what you see behind different averages or median lengths that are set for the minimum term. And then the next question. So the next one, so what are maybe what do we know about the reduction of minimum terms when there's a request to reduce that? This was created back in January, and now that we've done some file review, I'm not sure how much we can look into this. That's actually on a follow-up question I have to see if there's maybe a different way to go about this, or if there's something in the files we can look at differently. But yeah, we were hoping to kind of answer that question. That's kind of come up a few times. How often are they requested, and do people get a reduction, and what does that look like? So that one is a little to be determined at the moment. Then the next one, kind of another question, again, going back to the task force, just some of the goals and questions listed in there. So how often are minimum terms hearings held, and how quickly are they held when someone is sentenced? So really trying to understand when someone is sentenced until they have the hearing that sets their minimum term. And the examples today, I think, were really helpful to kind of talk about how often there's continuances. So there may be a longer period of time before someone gets the minimum term, but there could be very good reasons for it that relate to kind of legal processes or other things that need to be figured out. So that was kind of another question. And I think based on our kind of file review so far, there might be some information we can kind of glean from what we've collected to look at this. The next question. So another thing that was listed in the resolution was, how does the current process to set minimum terms fulfill the administration of justice? Or one of the goals in the resolution was just understanding how the minimum term process currently fulfills the goal of administration of justice. So that one, I think that would be really interesting to get feedback from the group. What does it mean, administration of justice, in terms of what we could study or look at there? But one of the things we looked at was, or some potential research questions could be around, do you see similar minimum terms for similarly situated people? So kind of maybe getting at consistency or sort of procedural justice. Do people get terms that maybe they kind of expect that they would get? So those were a few kind of potential research questions we looked at under that.
Can we jump in once you want one other question or you want to please me?
Do you mind if I?
Nope.
I got one more and then, yeah, okay. Thank you. Okay, and then I guess the last one is more a big picture question, which is about how does the current process around minimum terms relate to the overall big picture of like what is the purpose of sentencing? So how does it achieve, what are sentencing goals? Sentencing is actually, I think, one of the most complicated things to study in criminal justice because sentencing achieves many goals and they don't always align with each other. So you might be trying to achieve rehabilitation, but you might also be achieving deterrence or other factors. So those are the types of questions we probably won't get to within the task force because they require a lot more system-wide data to do that, but not completely off the table. We never know. Those might just be a future research agenda or recommendation to look into further. So those are all, the big picture stuff. And I wasn't sure kind of what would be most effective in terms of getting feedback for the different questions or if people have specific ones, but we can start with that.
So you have one more slide.
Thank you. And this sort of relates to just everything so if you have questions about, we could talk about are there gaps in data I haven't mentioned. If your agency has information that you think would be helpful that we can work with, definitely open to that. We also know that some of the larger sentencing data could be really helpful, but we work a lot with that data, and I don't know if we could get anything together in time to kind of fill in the big picture. So kind of, are there other data gaps that we haven't thought of, and specific questions? And then the other thing too is, I've been focusing on administrative data from files, data that agencies collect. There's other forms of data. So it could be interviews with individuals who've gone through the sentencing process or other kind of interviews, qualitative research that could be helpful, that we might be missing as well. And that can be really helpful to filling these gaps because we know that we don't have records or information on everything. So that, doing interviews with people can actually be really, really helpful to fill in missing pieces. So that would be the last slide. So I guess we can start with questions.
Just sort of on the backdrop of, I think I might have mentioned this earlier, the original task force bill did not include the voice of victims or community safety. And so we had to lobby on the voice of victims into this process. And so just to comment on the administration of justice, there's nothing that reflects what the impact of this will be on the statutory rights of victims to be notified about the hearings and to be heard. And so there's a robust computer database that's housed in the Department of Public Safety, the SADMI database that provides notifications to people about the minimum hearings as well as other important events about the release or escape of offenders. And so that very robust database that is accessed by victims, if people don't receive notice, then their other rights are meaningless if they are not notified about the right to be heard. There is no parallel system in the judiciary. The administration and judiciary declined to be part of the SADMI system. Tommy Johnson might still be online, met with them back in the days when the SADMI system was created, and they declined to be a part of that. So there is no mechanism to notify victims within that system of that right. So I think looking at the administration of justice, if there's no factor in there about what's the impact on victims, about possible restitution practices, the right to be heard, the right to be notified, that there's just a whole piece that's missing. And then also looking at human safety and the impact of all of that on the safety.
I can say one thing about that. I think one massive benefit of the way that this task force was written out is that not only do we get to put forward recommendations, but we actually get to write out legislation. And so those are the exact types of things that we can try to include and make sure that that piece is included. Because I know across the country, where we don't have rules setting the minimum hearings, Savin exists across in other states. And so I don't think it's a massive ask, to put it in there and kind of.
Actually, my point is not about whether or not we would
you see that we would want to make a change. My point is, what is the impact? I understand what you're saying, that if you have a viewpoint, that's what you might propose, but you don't know the impact and the data doesn't reflect what the impact is, then that really misses the point of making a decision based on the impact of the.
Well, honestly,
And Angie, we worked extensively with Angie actually on a restitution project. We have a national model of the restitution project, thanks in large part to HPA's like belief that the offender should be held accountable. And so actually, I know she's aware of all the PSD's databases and the information that she did that though.
Yeah, and I was just saying, and I think one thing I should probably preface too is, this is just a big picture overview. It probably would make most sense if maybe there's a few, if we could talk through a little more what you're thinking, because part of it is if the data is there, can you actually use it for research purposes? Or maybe that data isn't kind of what you're getting at, but then what are the, kind of refine with what is the research question and then figure out how we're going to get there. And
I guess part of my plea in addition is that to consider why victims were part of your research question. And so that as you're thinking about it, what I think this voice is about is making sure that the void in considering reform that, of non-including victims of community safety is huge in terms of the outcome. And that the Justice Reinvestment Initiative of 2012, and I know Steve and others were a big part of that, was a balance between community safety, the needs of victims, and what's best for, what we do best to make sure that offenders are rehabilitated and make the system. So I think that this is a good balance for anybody doing legislation or caring about what the outcome is for our state.
And so I think at a later time, a lot of the questions you were asking regarding trends, that kind of stuff, we can sit down and go through extensive things. So maybe from there you can narrow it down.
what you mean in terms of presenting that analysis?
Well, we can fill you in with some details, things that might be overlooked in the question because they're very general, but there's a lot of specific issues you may want to consider.
Yeah. So I actually have kind of a fleshed out outline of like a million kind of questions. It's actually even a shorter version of kind of everything else. Yeah. So, and I think we're such a big group. I was thinking like these kinds of discussions are helpful to ensure, there's no specific question yet about victims, but as we've gone through each question, it's kind of like, is that information there that can we use it? And I think that has been kind of a challenge of really, there's not really a systematic source, at least in the databases that we've been able to use.
Can I just say on the issue of victim participation, I think for the purposes of this task force and the question that we're being asked to address in terms of who's responsible for the minimum sentencing settings, it would be very helpful to put some meat on the bone with respect to the anecdotal evidence that victims feel more comfortable in front of the parole board versus in front of the court. Right now, it's anecdotal. Right now, we have so-and-so told me this, I've heard this from several people, and if we can get some data to then back up whatever decision we make, I think that just adds to the credibility of whatever report we produce.
Is there a national standard? Is there a best practice, Dave? You. Carl, wrong one. Carl.
National Center for what?
For victim participation. Judge is asking the right question.
Well, honestly, I think Pam was the expert on what on the array of things that happen around the country, but every state has their victim rights, either constitutional provision or statutory provision with a lot of similarity. I think Hawaii stands out in terms of the restitution order that's happened here.
But I think the point that the judge is trying to make is that it would be refreshing to be like some type of actual data instead of just people's perceptions, because our office has gotten calls from victims saying they don't want to go to parole because that's yet another hearing that they then have to attend. Like they just want it done. Like they're just desperate to have it done and not have another step in the process. So, there are mixed stories out there and I don't know which stories are getting elevated or not. So I think that's a good point.
Yeah, to that very point, I mean, I have feedback on both sides of the equation, right?
Yeah.
I have feedback from victims who have good experiences in front of the HPA and want that system to stay in place. And I have the exact opposite, right? And it has nothing necessarily, well, yeah, it's just for a variety of different reasons. They're very firmly on the side of some sort of change coming about. And so I was thinking of the same thing, and just how would we go about getting that data? And I don't know that it exists anywhere other than for, you know, prosecutors' offices, I think, to think about putting together a survey to be able to collect the data.
That's a good idea.
Because I mean, yeah, I can give examples on both sides of the equation, but it's all anecdotal. And so, you know, what tool can we create to collect that data to help inform that portion?
To that point, I think the data is important, but the reasons for the data is also important, because maybe part of the reason why the sentencing hearing, the court sentencing hearing, is so dissatisfying to victims is because maybe they don't understand what is going on in terms of the parlance that we use, the indeterminate term, the open term. You know, I tell the attorneys who appear in front of me, say what you mean. You're asking for this person to go to prison for 5 years, 10 years, 20 years, whatever it may be, so that the people in court can understand. And it may just very well be that if you add then the minimum sentencing process into the court hearing, maybe it might be more satisfying for victims.
Right.
I don't know. You know, maybe the reason why it's unsatisfying is because they don't know sort of what to do with the maximum term and where to put that in terms of its proper place in as to what the actual sentence is. Yeah, they know the maximum amount that this person has to spend, but that's the maximum. That's not the actual time that the defendant's going to spend in custody.
Right.
And maybe that's the missing piece for them. I don't know. But so I'm just saying, we have a number of data points that are important, this among them, but it's not just the data, it's the reasons behind the data that I think are critical.
I think they're just happy if the guy gets sent to prison. Basically.
But also if they have like the end goal, like if they know it's done. Yeah, if they know it's done.
Yeah. Always encountered. Yeah, I want to shift gears a little bit. There is one sort of data question in HCR 23. We haven't talked about it. It says something like, do the minimums that the HPA sets, how do they differ from minimums that judges set?
Right.
And my impression has been that that's a pretty rare occurrence. And I'm guessing in the data pool that you're doing, we're not going to see any information, or if we are, it's going to be such a tiny end, we wouldn't comfortably say anything about
That judges currently set, or that they would set, had their responsibility for
it's talking about what they currently said, and I think it's referring to the issue that you pointed out, that the HPA change of minimum.
And that's
yeah. But I gather that's relatively infrequent. And I just wanted to throw that out there, that's probably something this group is not going to be able to answer based on the data.
Well, I can respond, you know, it's a very, very, very small category of cases. I know one of our colleagues had one long ago, and it's a small data set, but you would need someone charged with the mandatory minimum and then a plea agreement in which they take that away and it's open sentencing. And then you actually can compare the mandatory minimum to what the actual minimum would be. That's the closest thing, I think.
That's interesting. But again, a very small
set, right?
And I just wanted to be clear up front that I think there's one thing in that resolution that we're not going to be able to say again.
Well, and I should follow up with, I think maybe I should clarify my approach. A lot of what I did was sort of just highlight some general questions I think we can answer this year. But I kind of just scaled back on things that, and because I'm familiar with the data, I know we have the access to it and was just, focusing on that. I think the real challenge, that I was struggling with even for today is how to convey, because there's so many great questions, but the data is just not there, or it's not collected in a way we can really get at those types of questions. So, Carl, I thank you for bringing it up though, because it's specifically mentioned in the resolution.
But yes, I think we would have to work from judiciary data and kind of structure something and then kind of build like.
A longer term project.
Potential, but.
Like, is the question you're trying to answer, that I know is in the resolution, is that a timing issue or is that like the data doesn't exist issue?
It might be both. It's certainly a timing issue. It's a complicated question. But the problem is going to be it's an infrequent occurrence. And, you know, maybe there's 50 of those over 10 years or something, and you could say this is what happened. But
Yeah.
So just a sidebar comment. What we've noticed in minimums is when mandatory minimums are applied and you have first timers coming through and the repeat offenders, there's a cycle. And what happens now is we've seen a cycle where we've noticed an increased number of mandatory minimum applied to certain sentences, a greater number of individuals. So the first time around, if they were like 5-10 years ago, and they're coming back in the system, they're getting set with mandatory mins. And there's a growing number of those because it's kind of cycling through. So you have to look at these trends, and there'll be a time when there's none at all. But because we see them in all our mandatory minimum hearings, it's a, dang, this guy got a 3.8, or this one got a 1.6, and the hell, but one of the other charges got nothing, but now with these other charges, we have to look at the man mins,
I have a question, Eric. So I know that when people look at trends, they kind of lump things like, what are the minimums that Class Cs get? Right, but as we saw today, everything is nuanced, right? It depends on the individual, it depends on their history, it depends on their character and attitudes. But that's never captured in data when they look at, these property offenders are getting the average minimum term on X amount, but we don't know, it doesn't look at the history, right? But that's what goes into determining minimum term is the history. So when you talk about trends, is there a way to capture, like, for this kind of person with this kind of history and this kind of character and attitudes, this is the trend? Because otherwise, it is not an accurate picture of what's really going on.
Yeah. So that, thank you. That is, kind of under the first question. Yeah. What are the trends? But you're exactly right. So beyond what is the average for each conviction is really understanding. And that is when I feel more comfortable saying, yeah, we can look into that. We can look at what was their criminal history. Also, most people have multiple counts or multiple convictions. And so the highest one is going to impact. So if you just take what was the highest, if you're looking at the person level, but also you can disentangle, look at for each type of conviction that there is a hearing for, and the characteristics of the person, where they're from. Yeah, so if we, the different data sources between like the criminal history information, and then also being able to come here on site and really review the files to really get in through all that additional information about offense severity or kind of some other factors that we can dig into so that it's not just this is the average, but kind of looking at it in some different ways to understand what might be behind those averages.
And can you use, if you have enough data, so for example, if we were able to take the data from the materials that we were presented with today, right, which would include considerations like prior probation revocations, prior parole revocations, data on the nature of the offense, so a broad spectrum of data points. Can't you run an analysis on that to see what the relationships are between those factors and the ultimate question we're trying to answer? I'm sorry, I'm trying to explain it away, but so this comes from my first job in a prosecutor's office was political, not as an attorney. And it was running a regression analysis on probation violations. So, I mean, would that be informative or helpful in this process, or that's like way off?
I think that's ideally what we want to do.
Okay.
So, yeah, Cheryl, so I think what you're talking about, yeah, is there's the descriptive part and kind of breaking it down to understand that. And then there's the predictive analysis, like we see differences maybe, but do those actually predict differences? Is that kind of the next step of the question?
And then I think the other side of that is, to Cheryl's point, data's only gonna tell us so much.
Yeah.
At the end of the day, there's so much that data can't inform us on, those nuances that he said, right?
But just to jump in on that, I mean, like, I know HPA, they issue the means, I think, and they issue that range all the time by year. And I think, Cheryl, you do raise a good point, but at the same time, there is something to be gleaned from it. I mean, you sit down with the client and you say, okay, let's get realistic. Your 2 out of 5 is good. It's just it's also an expectation buffer, right? I mean, so there's something to be said about that.
Well, yeah, and I think with means, for example, I mean, it's an average. So you're just looking at, so if you have 100 decisions and you have one average, it sometimes doesn't tell you much. What if you have one person that does something kind of an outlier, but then everyone else hovers around one mark and you just have the average? So that's the other thing too, is kind of being able to look into that a little more to help with the goal of what is the median, or what is the mean, or what's predictive? What does that actually translate to? What factors are maybe driving certain minimum decision, and are there certain factors that maybe predict more than others that behind that decision?
How does that translate though into if the judges have to set minimums? It's HPA has done a good job, I think, of looking at their data and looking at averages. But if the question ultimately answered by this committee is it has to shift to the judges, to Steve Ong's point, you're gonna have 23 different judges who do criminal work statewide. And if it's a fully indeterminate minimum sentence, you're gonna have 23 different answers in the same situation. And I'm not an expert in politics, but my instinct says to me that if that becomes the case, then the legislature is going to want to they're gonna get complaints, and they're gonna want to then promulgate legislation to harmonize the results statewide.
So you mean like sentencing guidelines?
And that's what like the federal sentencing guidelines, all its disparities with the.
But judges don't want sentencing guidelines? I don't mean that. I'm just trying to understand.
I think the question is, what's to his point is, does it, you can set all the guidelines you want, but judges trying to stay away from this.
Judges want discretion.
Right.
That's what judges want. We want discretion.
And that's what they have right now. Most times.
That's good. I mean, well,
discretion.
Yes, well, yeah. I'm not going to.
For 10 years.
Yeah.
Well, we're a little over time. Did anybody else have any last minute questions? Awesome. Well, otherwise, I really want to thank Pearl again. That was really amazing. Thank you all. Thank you, Sharon, for being on us together, and also Charles. This was a really great meeting, and I appreciate all of you. So until next time.
Thank you. Thank you.
Thank you all.